Good morning, good morning, good morning. It's the day after a 6-0 victory for Canada in the World Cup, one of the largest margins of victory, I think, since Mexico defeated Honduras 7-1 back in 1970. Same cup where Pele was able to make his triumphant World Cup win after a couple of disappointing outings for the fine young footballer in 66 and would have been 62. Yeah, because 58 they won it, but he didn't get to play very much. There's a great documentary on Netflix as far as the Brazilian team. I don't think it's called Pele. There is one called Pele, but that's not the one I'm talking about. It kind of touches on a lot of the political upheaval that was going on in Brazil at the time, but just touches on it because it's more of a backstory to what the team was facing. But Brazil wasn't always the perennial favorites. They were often, I think, a little bit, they didn't believe in themselves. They felt like a second-class footballing nation and, were known for saying sorry rather than doing well, which is sort of like the Canadian team. We have a reputation for our apologies before our fine play, but that was some fine play. So go Canada. Let me just take a look in the chat, make sure that I'm not on mute or anything stupid like that. Where's the streaming window there? I see Disney Mom, Hello Baby, LZB, Amy Zeitgeist, another one to say, Margaret Adam, Lakeisha Prelo, Nana of 4, Charles Grieve. Fantastic. We've got a great start. We've got a good crew of people here. Going to start the timer widget. Give me 10 minutes to get myself in sorts. And I'll run down the show today, too. We've got a pretty interesting section of trial to watch. Now, if you remember last week, I left rather abruptly. Mr. Henderson was just about to get up and talk, and I was like, I'm not watching Mr. Henderson when Canada's playing. And what game was that? Was the Bosnia game. We were down by a goal in that game, too. And I'm just sitting here, like, watching Mr. Henderson and looking at the Canada score on my phone and going, I can't just podcast while Canada loses. I have to go. Anyway, so I cut off Mr. Henderson. Turned out that was actually a fairly interesting bit that's going on. Not really Mr. Henderson, but what is happening is Mr. Henderson is arguing emotions in limine. And I brought up a fancy motions in limine screen. So we'll talk about more of this when the trial or when we get to that part. Just pause it there. Motions in limine set for at the threshold. A pretrial request asking the judge to decide whether certain evidence or arguments can be presented to the jury. The motion is argued outside the jury's presence, so the jury is not prejudiced by the inadmissible information. So that's what's coming up. The main motion in limine that is being argued is whether they can bring up the battered spouse defense during the opening arguments of the trial. At this point, they have been ruled that they're inadmissible. Judge Cranick has said, you come up with an overt act. If an overt act comes into the evidence, then everything's a whole new kitty. So we have that to look forward to. We also have a Richardson hearing, and the Richardson hearing is another thing that I did a little research into. That's way too quick as a slideshow. Let me just change the speed of that. Transition. Okay, maybe it was just because the last one was set to go. But yeah, the Richardson's hearing, that looked like it was almost, when it happens, Judge Cranick is kind of like, well, got to do it. Don't have a choice. This is now a Richardson hearing. And this is because Sarah's side dumped a bunch of documents on Mr. J and Mr. Cacciatore, the day before. I think jury selection's just wrapping up. And then they had to go through a whole bunch of health records from Sarah's last 2 years while she was being treated as an inmate. And of the 115 pages, it turns out that just 15 were relevant. So But yeah, that's the purpose of the Richardson hearing, so we'll be doing that. Danielle Chavon, welcome to the morning chat. Welcome to the Fine and Dandy, celebrating her membership. Thank you, Danielle. Great to see you here in the chat. See, Ruda Schuler is here too. All right. All right. This is looking like a lot of fun. Go back to that launch screen. We've got 6 minutes left here. I'll show off my medical. Oh, maybe I'll go to the main screen and get a little bit more. Yeah, so morning snacks I have, these are my medical snacks. This is just frozen fruit. Decided if I put some frozen fruit here, instead of getting peckish a couple hours into the podcast, I can eat, what would you call it, room temperature fruit. Yeah. Little medical coffee here. Got my medical cigarettes. And I haven't been doing this lately. No good for my voice. What's in there is my special green tea and lemonade mixture, which is quite soothing on the throat, and I don't know why I got away from it the last couple podcasts, so I'm back to it. What else have I done? I'm in the true crime basement here. Yeah, I've set up a camera so I'm not looking at the laptop as much as I should be looking at the camera when things happen. Let's check the lighting. What can we do with that? Yeah. Ooh, that's not bad. It's not bad. Not as bright. I'm still lit. Maybe we'll stay there. Maybe we'll stay right there. Okay. Let me shut that part off. Let's get the chat up on my phone. And we'll go back to the timer so we know how much time we have remaining. 5 minutes. Oh, yeah, and, don't want to bury the lead, but she's going to get denied her snacks, so we have that to look forward to. No snacks for you. It is my understanding that Miss Boone is getting the same snacks and food that any other inmate gets. Because of that, her motion is denied. Denied. All right, that's YouTube. Okay. Shh. Okay. Oh, I was watching Danielle Chavon's show. What was that? Midnight release there, Danielle? I was out making rather merry. I didn't even realize Danielle Chavon was releasing videos at midnight Pacific time. Check that out if you haven't. There's new Danielle Chavon content. Sunday Fun Day is also coming, so there's that to look forward to as well. All right, I'm logged in, which means the stream is definitely working. Looks like I am 20 seconds behind real time. Okay. Charles Grieve has a medical cigarette and a bowl of cherries. Sunday in London. Life is good. Bowl of cherries, and for me, everything's peaches. And I imagine, yeah, if you're in England, you're also quite happy with the way the World Cup is going. My God, Harry Kane with that brace to start off the game, was it versus Croatia? Croatia's a fine team, too. There's nothing to sneeze at there. Bless you, But yeah, England came out. They look fantastic. I would almost say that they may be the team to beat in the tournament, especially the way Spain looked versus was it Cape Verde? Although Spain never starts strong in the World Cups anyway, so don't want to count them out. But yeah, England could be their first since 1966. So. Very exciting FIFA World Cup tournament for all of our international viewers. I hope your country is still in it and doing well. 2 minutes to go. Is there anything I need to prepare? That's our court screen. Maybe I'll take down her snacks until we start talking about snacks. Take those down. There we go. No snacks for you. I have to change the text on this. We're now looking at what is the date? This is streamed October. Okay, so we're still on the 16th. We're going to finish watching the 16th video, and then we will watch the complete 17th, which is quite possibly the last day before the trial. Paintbox Tunes, hey, welcome. Welcome to the chat. Kitten Pushers here. Perfect. Everybody's made it just in time. Well, everyone who's here has made it just in time. Otherwise, they wouldn't be here, would they? There's my Zoom screen. Okay. Okay. Doot, 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 doot. Doot, 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 doot. Intermission. Luther Rose says, is there any way to copy a name or handle? I have a short-term memory, so halfway through the name, I just forget what I'm typing. Just a question. It's a great question, Luther Rose. If you're on a computer or desktop, it's remarkably easy. All you have to do is type the @ sign and the first couple letters of the person's name, and then all the choices come up, and you can just click the name. Unfortunately, on mobile, where that would be a super useful thing because of how tiny the mobile screen is, you don't get that option. So what I recommend, Luther Rose, is when I'm on mobile, I'll just shorten people's name. Like Ocean Sounds 1 is there. I'll just say, hey, Ocean. Or Kitten Pusher, I might call her Kitten capital P. And as long as you're in a chat, with less than 100 people in there, most people will pick up their name. You're not going to get it in highlights. Another thing to keep in mind, Luther Rose, you don't need the @ sign. If you type a person's name, and I'm going to test it right now with somebody. Let's see, Bella's mom. Good morning, Bella's mom, 1016. I'm typing your name into the chat without an @ sign just to see if you end up getting it highlight, because that was happening for me when my name was just Dan D instead of Dan D True Crime. Whenever Dan was in somebody's, if somebody said Dandy, the Dan would highlight as though somebody was mentioning me. Good morning. How are you? There we go. But yeah, Luther Rose, if you're noticing, like, how the hell are people typing, these long strings of characters with uppers and lowers and symbols or whatever else, it's probably because they're on their laptop and just started typing and it finishes for it. But yeah, that's a little tip. If you're on mobile and you are wanting to tag someone, skip the @ sign, I think, because I think it'll still highlight the name the same way you'd expect. Oh, the zeros are there. Well, if we're on zeros, we should be starting the show. Let's go to Judge Kranick, and we're going to go back a little bit. So if you guys watched the last show, if there's people here on the replay crew, we're probably skipping back about 10 minutes from where we left off the last show. So by all means, feel free to skip ahead. But I felt like it was important to start from here just so we got a little context for the motions in limine argument that is being brought forth by Mr. Henderson. Another thing to keep in mind, the audio is all over the place. I don't think they've got the mics connected at the defense table. So there'll be some places where I'll have the headset turned up on full and try and repeat it for you. I'll also put up captions.
Evidence at trial. But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about.
This is also the beginning of the bless yous. We haven't seen a lot of it in pretrial, but the bless yous begin here and they don't stop.
In the self-defense realm that the state has cited to in their motion, that an overt act is needed. What is the overt act?
The overt act has to come from testimony, and I agree in this case.
You see, Judge Cranick, yes, it does, and it hasn't. So, and what the defense is trying to argue is, we brought it up. You might not have noticed it, but we've already mentioned it. It's okay. Tell me. Well, we don't want to give it away, and then the state will know what we're going to defend ourselves with.
But that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing...
It's the first time he brought up scintilla, too, because it's not until he rules on it, in the trial that scintilla came up again. And I remember when we watched this live, I was on Caricatures watching live with that live chat when it was happening 2 years ago. And we're all like, what's a scintilla? I don't think there was a scintilla. It's not a scintilla of proof. There's like half a scintilla, a quarter scintilla at best.
...with the jury instruction right now. What I'm dealing with right now is pre-trial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation.
And that's what
my takeaway
happens.
from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense. Has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what...
It didn't look like Judge Cranick was terribly impressed by, I don't know what happened at the deposition. James Owens did the deposition. It's like, guys are on the same team. He could have given you the notes. It's not my fault. You don't know what was said in the deposition, Mr. Henderson.
What does Ms. Boone, in this case, testifies to on...
Ooh, Disney Mom asks a good question. Disney Mom 5 says, Dr. Harper, what an idiot. Where did Owens find her? Dr. Harper had been part of the case since very early. Like, I wouldn't be surprised if she was one of the first experts that was brought on by one of her first lawyers. The battered spouse part of her argument only came up when Owens came onto the case, though. And that's what kind of makes... Well, it makes a couple things pretty... worth talking about. Owens gets so upset that the expert for the state has a change of opinion, where she basically is able to identify, I think, more narcissistic traits within Sarah. And, that didn't come up, and the judge says, okay, well, you can depose her right now and find out if there's anything new that's changed. But Owens was, irate about that. Meanwhile, Dr. Julie Harper, on the case for 4 years, only when the Owens team comes on and says, hey, we're trying this battered spouse thing. Oh, yeah, okay, I'll go along with that. I'm just speculating. I don't know that she said that because, it seems like a stupid thing to say as an unbiased witness that is taken an oath. But in any case, her opinion changed just before the trial. And, That's where Julie Harper came from. So it wasn't that Owens found her. She was already on record. The one that Owens did find, and I'll give him credit for, was Michael Brannon. Michael Brannon was the expert who testified in the... I keep getting it wrong. It's not Marcia. It might be Maria Thompson. Regardless, case in Florida where the woman shot her husband sleeping on the couch. 6 of the shots were to his back. And she was acquitted because Dr. Michael Brannon was able to establish a history of battered spouse and that she was always living in fear. That case was in July of 2020, so very recent, and I think it was just Owens looking for a quick win, like, oh, if he helped her, then this is perfect. And he was actually a fairly good expert, so, credit to James Owens. When Michael Brannon got on the stand, he didn't give a Julie Harper. He gave an honest opinion, and when the state asked the same questions about George, Michael Brannon's like, yeah, George could have very well been a battered spouse. Yep, that's consistent. Yep.
And if any of that, excuse me,
hey, A to B.
if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling.
Marcia. Thank you, Blue Giraffe. It's Marcia. Marcia Thompson was the case that Michael Brannon was part of. Marcia. And yes, Luther Rose, Brennan did help the state more. And I think it speaks to the importance of expert witnesses that are truly experts and not team members. You can get hired by either side, and, if you're running a sports team, you pick the guy that's going to fill the needs of your team best. But it shouldn't change the way you play depending on who you get hired for. If you're a ball player, you play ball for whatever team hires you. And I think Michael Brannon did a great job of answering honestly and being a true expert.
The evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
I love when Judge Kranick doesn't agree, but he doesn't need to hear anymore. So instead of arguing the point, it's like, okay, well, you're wrong. So anything else? Okay, let me go to the other side. Hey, Kentu Sukaroy, welcome to the chat.
Parties are allowed to
Super
depose
Kelly G.
testimony based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day.
Congratulations, Bella's mom.
And what is not permissible under the case law that I've cited, in particular the one that says...
Bella's mom's been a member of the Fine and Dandies for 2 months, celebrating a membership. Good morning to you, and thank you.
You get a threatening text, and then 2 days later...
Barbara
you
King.
go slit
Hey.
somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog...
Ooh, this is a bad analogy. He sets it up by letting you know it's a bad analogy, too. But yeah, George, bad dog. Oh, Mr. J warms up as the trial goes, but I remember us kind of being critical of him in the early days, and this is probably one of the reasons why.
Bad dog bites. And that bad dog is bitten in the past.
Let's just go back to hear the full bad dog.
On this particular act taken by the decedent on that particular day, what they want to do, and what is not permissible under the case law that I have cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog, and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an...
So that is the correct part of the analogy. I don't think comparing George to a bad dog is the best. I think the Star Wars analogies landed a little better than that one. But the main argument is, yeah, a dog bites you 3 years ago. Just because the dog approaches you in the yard, you don't, hit it with pepper spray because, dangerous dog. It's like, if you had the pepper spray 3 years ago and it was being aggressive, by all means, a little shot of pepper spray. But yeah, you don't just do it proactively like, oh, that dog once has harmed me, so now I'm going to sneak up on it.
Overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking...
I got to pause again. Sorry for so many pauses, but Barbara King and the judge works domestic violence in his community. He knew who was the aggressor. And then Kentu Sukuroi, following up with Charles Greaves, says she's old grout in a nasty tub.
Yes, they are saying that the testimony will be different at trial. We are asking for the court to prevent them from saying anything about this during opening statements because they will know, based on the court's ruling, what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on in the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse.
Apologies, I just realized I had my court audio quite low. If anyone had earphones on, it's gotten quite a bit higher, and I've just made another adjustment, so be ready.
Any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Briefly. Somebody doesn't want to hear it.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing.
That has to be a much fuller sound for people who are listening on phones and stuff like that. Apologies, but Good news is we're just catching up to where we finished the last episode, so the sound was good at the end of the last episode. You haven't missed anything for the poor sound at the beginning of this one.
Jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has.
Prima facie is just Latin for on its face. So basically, is it evident? Can you see it, clearly? Does it have a prima facie case? Like, if you look at the basic facts, does it make sense?
To overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have...
That's exactly. So that's a prima facie case. It doesn't mean she's guilty, but it means based off of fact 1, fact 2, and fact 3, there's a case. There's a reason for her to be here before us today.
Butchered that last element, but those are the elements that need to be established based on the jury instructions.
Blue Giraffes, that's a great point, and that's actually why I'm so interested in showing what we're going to be watching today. This hearing and the next hearing, Judge Cranick gives 4 or 5 free TED Talks on, how to conduct yourself as a lawyer in the Florida 6th District. So they're free lessons for James Owens and Tony Henderson, but they're also quite interesting for all of us aspiring bloody keyboardists.
Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's...
Nana 4 brought up Class of 79. That was a crazy movie. I saw that when I was too young to see it, but I remember that being that was a crazy movie.
Argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Yeah, do it. I really love that exchange. Because first, Mr. Henderson just outright you're wrong, Judge. And you could, good for Judge Cranick for not, showing it on his face, but us knowing exactly how reserved he is, you can kind of feel it.
It's not, Judge, but I find myself...
Look at that. No reaction at all. No, it's not, Judge. 38. We'll go to 37:52. Okay, this is 10 seconds before.
The point of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is put. This is what.
Yeah. Okay. That's what I've been asking you to do. So do it.
This motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase.
There we go.
That means he's about to get out of the suitcase.
There we
Now,
go.
based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat.
Okay, so everyone, let that sink in. You know what? I'm not even going to comment. We'll just go back and listen to that again. This is part of Sarah's defense. We'll go back 15 seconds. This is Overt Act establishment and Sarah's defense.
It's out of the suitcase. It's followed up by physical evidence because there's a picture provided of Mr. Torres's hand.
You know what? I'm even going to slow this down just a little bit. Not a whole lot, but just enough that we really let this sink in what he's trying to say here.
That shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger.
So that's it. That's the overt act. It's like a gun. You don't need to wait for them to pull the trigger. That's the overt act. Not even that, because that's how she puts it in court. That's the overt act. True Crime Loser put it really well when he responded to this little bit as, okay, it's like a gun, except that it's not like a gun. It couldn't be farther from being like a gun. If he had a gun and a gun came pointing out, yeah, hit the gun with the bat. Your defense is because he has wounds on his hand that there was an overt act. So that's basically their defense. Because our client beat him with a bat, that proves that she was in fear of her life. Not just that she was a cruel, vicious shrew beating a man to death in a suitcase before she killed him.
You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Yes. Kitten Pusher, thank you. Kitten Pusher says, even if the most overt act thing could be open to different interpretation, he should say, or he should not say, you're wrong to the judge. I disagree. Or, I see the law differently. Would have been much better. No, you're wrong, Judge. There was an overt act. She's innocent. She's innocent. She sits here before us without snacks, without guilt.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part.
Big hello to Sagittariously Single as well. Thank you for joining the chat. Yeah, you're going to deny this, Judge Kranick, but that said, there's still an opportunity that overt act comes in.
With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724.
Thank you, Elsie.
State v. Woodson, 349 Southern 3rd, 5.
Sagittariously Single, not only welcome to the chat, but welcome to the Fine and Dandies, because you've received a Dandy True Crime gift membership from LCB. Thank you for joining the chat, and thank you for sharing the gifts, Elsie.
10, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. with regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it.
Just pausing there so we can see Chelsea Kepsel, and I'm speculating that it might be her partner. Only reason I'm pointing this out is we'll see the next day in court. They're sitting in separate benches, so they're associates at best. It could be that they came into trial together. You know, Chelsea's a married woman, recently given birth. So, yeah, she's not out here trying to cozy up to anybody. And we'll notice the next day she's sitting in the front bench with this gentleman behind her.
The court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome.
Okay, two things to look at here. Look how ill-fitting the shoulder pads are on this blazer that Sarah has. And every time she shrugs her shoulders, you can see the shoulder pads just sitting like a full level above where, yeah, it's not even connected, like poorly tailored off the rack. But, you know, what do we expect? We didn't expect her to come in looking like a runway model by any means.
And there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
Well, welcome to the chat, Roberta Real. Haven't seen you in a while. Got an upgrade to standard moderator, managing moderator, whatever. You're a mod. Welcome to the mod squad. Welcome, Greg. And I just wanted to point out Victoria's comment. I never thought I'd think this, but after watching Kinsey, Sarah looks smart. There's something to be said for that. Mackenzie talks so much and so da fuck. It makes me appreciate the attempts at intelligence that Sarah makes, where, you know, Kinsey's not worried about trying to appear smart at all. The fuck?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in the...
Yes, that's your...
So this is one of the appeal arguments, is that the instructions for the opening arguments was that they weren't allowed to bring up. So okay, let's just pay attention.
Your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay.
Okay.
Any other questions with regard to the court's order on...
But then that puts them at the risk. If they bring up battered spouse in their opening and they don't establish an overt act, then the state can say, they told you all of this in their opening of the case. They didn't prove that. They said this. They didn't prove that. So it's a big risk.
That matter. State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6 and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
testimony of other witnesses, not to anything else.
Oh, okay. So they're complaining because Chelsea Kepsel's here in the courtroom.
Response?
Is there going to be testimony? Not from the state. You've got state witnesses here, you know. She's allowed to be here to watch. I understand.
I love the look on Mr. J's face. Yeah, she's allowed to be here. I'm going to rewind that just a little bit. We're at 44:35. And we'll do a bit more of a zoom on Mr. J.
Witnesses, not to anything else.
Response?
Is there going to be testimony? Not from the state. You've got state witnesses here, you know. She's allowed to be here to watch. I understand, but I want to know whether she's going to testify. I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir.
I think Mr. Cacciatore had a bit of a grin after that, too. Let's see, 44, 46.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir.
No, he's just processing. Hey, Phil for Dom Russo, welcome.
I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible.
So this is one of the few wins that the Owens team gets. If you remember from the original interrogation at the end, they're like, you killed him, right? I thought about that. Okay, because he's dead. And why is this happening? Because George is dead. So those bits get pulled out of the trial evidence because it's just the opinion of the detective that she was guilty, but the rest of it is all stays. So it's a tiny win.
If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury.
Hey, Riley.
Section, which is comments directed to the court, was not placed, to my understanding, in their response.
And I agree, Paintbox. I love seeing Owens get frustrated. It's like seeing Foghorn Leghorn get upset with the chicken hawk. I tell you.
Any other argument?
Judge, this was a
I'm a
2-hour
rooster.
interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the two videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder.
They didn't need a confession. They interrogated her because she was a person of interest. Very interesting person in regards to the case.
Spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found. Do you need the cite?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay.
It's the judge again, like, I have it. I know Oda. I know Wagner. I know I know all of these. You didn't include it.
Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury.
Nonetheless, I have to live without him. Yeah, so do his daughters. Trying to make this worse?
And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question.
Thank you, Suze.
I mean, you realize you're the person that...
Suze what? Says, you notice so many things, Dan. That is one reason I enjoy watching. You know, it's the main reason I started the channel, because I, you know, like a lot of us, if you're here, you're probably as obsessed with the case as I am. And the more I watch stuff, the more I was picking up things. And it's one thing to comment in the chat, but, you know, there's a lot of other people commenting in the chat. It's like, hey, look at my thing. So I started a channel so that I could talk about all the things I notice, and I'm so glad that you guys are enjoying them along with me.
Killed him, right? Sarah Boone responds on page 56. I thought about
Pretend
that.
judges here?
And then lastly on page 92. Well, intention or not.
Speaking of intention, intentionally turn on all messages. I was on top messages on my phone. I am now on all messages. If I've missed anyone, like Pretend Judge that came into the room. Lakeisha Prelo. Well, I saw you at the beginning of the chat because I have it on all messages on my computer. But yeah, that's my bad. I'll take it. I make some mistakes. I'm not perfect.
Here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To
the extent that he is making the argument that they're expressing an opinion about the
No, the words, not his opinion, not his thoughts or what it...
Is James Owen faithfully reading the transcript is what he's asking.
Means, but the black and white verbiage is reflected in the motion. Is that what's reflected
thank you, Victoria.
in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Victoria Carmen bringing up my voice and mentioning I can do commercials. You know what that reminds me of? Morgan & Morgan. Morgan & Morgan has been sponsoring every true crime YouTuber for the last 2 years, and they have not sent an email to Dan D True Crime. Morgan & Morgan has thousands of lawyers, and not one of them's taken the time to throw a few dollars my way. So if you ever talk to Morgan or Morgan, just let them know Dan D True Crime has a great voice for reading their ads.
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, disagree with.
Hey, Buzz Boomer.
The Jackson case speaks for itself.
Buzz Boomer has a comment saying that while being new to the channel, found me through Danielle. Shout out to Danielle Chavon. I enjoy your style very much, and the foghorn leghorn was a perfect comparison to Owens. Yeah, he gets all like flustered and in a tizzer. In a tither? Tizzer? In a tizzer? I feel like it sounds like tither, but I don't think that's a word. In a tizzy? Tizzy might be right. Whatever it is, he loses it. He
Court has reviewed it.
Thank you.
All right. Thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death.
Sarah doesn't realize she's winning here. You can see her face. She thinks that she's losing on this one too. But the judge is basically going to throw out those three statements that they're a little bit more accusatory than they are interrogatory. So I think he made the right call.
So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is this expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the
Boom Shicky.
State's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well.
Okay, this is the motions in limine. Let's just take a quick second to review a motion in limine, because that's what this portion of the hearing is. So it's an opportunity to exclude prejudicial evidence. It stops attorneys from mentioning irrelevant, highly emotional, or legally inadmissible facts that could taint the jury's perspective. There's that taint word again. Preventing trial by ambush. And he does bring up trial by ambush when James Owens was talking about, I'm just asking questions, Your Honor. It's not a game of 20 questions, Mr. Owens. It's not a, surprise, here's my defense. It ensures the opposing sides don't surprise the court or jury with unexpected evidence. Yeah, no Matlock moments. That's for TV. Also, for saving time, settles evidentiary disputes early so the actual trial can run smoothly and efficiently. Important things to know is that a motion in limine is decided by the judge. These are strictly decided by the presiding judge, and it happens before or at the very beginning of a trial. It's a temporary ruling that is interlocutory. It means that they're not final, and the judge may change their mind and allow the evidence during the trial if the situation changes. It's a pretrial request asking the judge to decide whether certain evidence or arguments can be presented to the jury. The motion is argued outside the jury's presence, so the jury is not prejudiced by that inadmissible information. All right, let's move back to our court footage. now that we're all back up to date with what a motion in
Dave,
limine
you may
is.
proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018.
Marla, hey.
Third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So
Marlaw says it's unfortunate that so much time and effort was invested in defending the undefendable Sarah Boone. And I tend to agree, but I think that if we take a step back, there's knock-on effects. As much of it was wasted as far as, it's obvious she was guilty, and, what a ridiculous rigmarole to go through just to get to the guilty after 4.5 years. But think how much smarter all of us are about how the law works, and how I know personally when I'm watching trials, like I didn't really used to watch trials. I watched, that chapter. I watched stories about crime. But my knowledge of the law, just from watching way too many details of the Sarah Boone case, made it much easier for me to appreciate the Karen Reed trial, that Shannon Cellbright guy who turned red on the stand and didn't know what the hell he was talking about, Kelly Dever's testimony, Dever. There's a few things that my knowledge of the law, thanks to the Sarah Boone case, I've been able to appreciate trials on them. I wouldn't have watched the Robert Tella's trial. I watched that one just because I was disappointed I didn't get to see the narration testimony from Sarah. But so I'll make the argument that while it was a waste on Boone, it's not a waste for all of us. I think a lot of the pedantic exercises that Sarah forced the court to take really helped elucidate how the court works to a lot of people that maybe only watch the sensational aspects of crime. And, for our interest in this case, we're getting into the weeds. We're getting into what a motion in limine is. I always thought it was eliminate, like just eliminate. But maybe that's a root word for how eliminate came to be a word. In any case, I think we're smarter, despite the fact that Sarah makes us dumber. So, yeah, it's a contradiction.
for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand
See you,
through
Nana.
plate
Have a
glass
great
window.
day.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence.
Which she does, but yeah, Mr. J now was saying, you know, all these medical records that they're trying to introduce, there's no connection to battered spouse. So unless Sarah is able to make a connection between the fact she had to get 2 stitches when she went to the hospital and it being connected to something that George did, there's no reason to bring in her hospital records.
That she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive.
Sorry, I'm just going to take I feel like I might be pausing a lot again. I'll sit back. I'll enjoy a piece of fruit, maybe a new cigarette. But Disney Mom says, I've actually learned quite a bit from watching trials on TV than listening to people like Lawyer You Know or JD A Lawyer Explains. So I'll just take the chance to shout out a few other ones that are in my Next Witness is great for calling out. It does like a bit of a LawTube compilation, and you find out about a lot of other legal channels. I think I found out about Brother Counsel that way. Emily D. Baker is great for legal analysis. Runkle of the Bailey's really good. So there's a few shout-outs to LawTube.
Jury's going to have a lot of information to
Hey, Robin.
weigh and consider. Not every page of these 57 pages is
Robin, the ADR pro, says 8.
relevant. What is relevant is Yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive, and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not...
That's interesting. I don't remember that. So this might be when she got George's brother to beat him up by lying and saying that he was hitting her. Because 2017, and George is lying, I got jumped by a bunch of guys. I wonder.
Not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again,
how'd that make
there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial.
Yes, Disney Mom, he did say 487 pages, and that's exactly what he's upset about. He's like, we're 2 days away from trial. The offense happened 4.5 years ago. Now they've given us 487 pages of, COVID tests and checkups and, things that really have nothing to do with the case. But it doesn't stop, our job. We need to go through all those pages. So, he's not happy.
Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 40.
Yes, Phil, for Dom Russo, this is a left-handed cigarette, a medical cigarette, and does happen to be in my left hand. It's I'm ambidextrous. If I'm doing multiple things, I'll find a way to get that medical cigarette into my mouth with my non-dominant hand.
5 days ago, and I can't tell you how many pages of discovery there is that we've had to go through.
That'll be a great game.
And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records?
Did y'all not have? Just turns to addressing the prosecutor rather than the court.
Prior to me sending them to you? No, we didn't. All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware.
I know that.
That's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that.
I got to shut this down. You guys have been going yap, 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 yap. Let me just lay it out for you. Go, Judge Cranick, go.
I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down, and then based...
Again, I guess this might be the second time that Owens has interrupted, because Judge Cranick hadn't finished his thought there. He was still, like, kind of trailing off on the one word to say the next thing. I don't know if that's how they do it up in Milton, but... I don't think they like that here in the 6th District.
You've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yep.
Scotland, we've got a great international crew here, and I got to shout out the Scottish. Scotland drank Boston out of beer. I was seeing news reports. The Scotland fans, first they drank all the Scottish beer, then they drank all the premium beer, and then there's an interview with this Scottish fan who's like, yeah, we drank all the beer. All that's left is Bud Light. Shout out to Scotland. Well done, drinkers.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well, the state's position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a .31 BAC.
Who gives a fuck?
Every time.
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
I have
window.
to look at the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk.
And Victoria Carmen says, still better than pro se. Can you imagine? And that's worth remembering. We've got 5 days of trial footage when we get to the trial. Each of them's about 8 hours long. We'll break it up. We're not going to do, a day for a day kind of thing. But 3 weeks was how long Judge Cranick had scheduled for the trial, thinking that Sarah was going to be pro se. So it shows again the wisdom of Judge Cranick and the forethought of knowing what a nightmare she was going to be, but also shows how much was saved by having an actual person with legal experience, whether his ability was in the top 10 or top 50 or top 80%, that can be debated, but having some ability definitely helps speed things up.
In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records.
And I'm just speaking off the cuff, but I don't think that's how alcohol works. I don't think people are fine at 2 times over the legal limit, but the minute they turn to 3 times, they turn angry. If you're an angry person, the alcohol lowers your inhibitions to anger. You don't turn into an angry person when you hit that 3rd degree.
Narrowed it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. It's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
And we know now it's going to be because Sarah claims that it was, her brother coming to Sarah, or, defending Sarah's honor. You don't hit women, George. But yeah, it's specious, the connection. They do manage to get it into the case, but
that's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
Do we have
That's
any,
not how motions in limine work.
Do we have any Norwegians in the chat?
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
Okay.
That's it.
Response.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the 3rd day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago.
I never got them. 2021, I never got them. It's like, yeah, your attorneys got them. They went to the people who needed them. 10609.
21. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both. In the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF.
This gets interesting too. We didn't realize it at the time we were watching this, but this is the state basically saying what evidence they're holding back for the rebuttal case and what evidence is part of their main case. So I'll keep track of it and keep you guys apprised, but that's what's starting to come out here.
From the thousands that it was.
Hey, Kelly,
and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to
we don't want much, but we know we love it. Watching Boone.
Bring the point about the BAC. Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date...
Those terrible shoulder pads. Like, I don't know who thought that was a good idea.
Again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion. Exactly. You might as well be bringing her to trial for attempted murder on the previous attempt on his life. Unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the depositions read. Only on that day she used his brother instead of a suitcase as her weapon of choice. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow. Yeah, it is a very cheap secondhand suit. Exactly, is that hee-haw that's mentioning it. Look at, like, not only the shoulder pads, but you could see the shoulder pads lift a whole second collar around the back of it. Tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol.
Plain well, Mac had to join the chat and let us know that they were thinking the exact same thing on those shoulder pads at that view. Yeah, this is like, 2024. The shoulder pads are Betty Broderick trial.
Content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance, so I'm going to overrule the state's objection with regard to those.
Ooh,
However,
that's a great point. So Candace says, I think the girls chose ugly clothes for an ugly person intentionally. Something to be said for that. I remember growing up, there was quite often, and it's a little mean. I saw AG Tactical actually bring this up, and that's why it's at the top of my head. Most girls had their ugly friend, and the ugly friend's job was to make the other girls in the group look better. Shelby Anderson and Lauren Henderson look fantastic next to Sarah Boone, so this might have been intentional. It may be malicious.
the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right?
Charles Grieve, is that a little ZZ Top lyric there? I ain't asking for much. Doom, 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 doom. I said, Lord, take me down to Lowell. Do, 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 do. I'm just looking for some tush. Hey, 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 hey.
Clarification or questions with regard to the state's rule, or the court's ruling? Defense. All right, thank you. That now takes us to the objections to the evidence.
Home out on the Grange.
We have the defendant's objections to state's digital exhibits.
Here we go.
Filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
Yes, Plainwell Mac says, just evil vibes from her. I'm so glad to be able to rewatch as I miss so much, and knowing the outcome is bliss. It's a lot easier to watch all of these machinations and steps knowing that the end result is going to be there instead of like, oh my God, she's not going to get off because of this technicality. So it's fun watching her just spin her wheels in the mud and get nowhere.
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
I'm sorry, Detective Wolbefett, is it Shelby Andrews? Shelby Andrews is the jury expert instead of Shelby Anderson. My apologies. I do try and make a point of giving both full names for Shelby and Lauren because they've been traditionally referred to as the girls. And they're more than girls. They are legal experts and deserve to be treated as such. So I think Lauren Henderson is actually even a full lawyer, just is acting as a assistant to this case. But yeah, Lauren Henderson and Shelby Andrews is the blonde jury expert.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything.
I don't want to be too crude, but it seems like Sarah's wearing her boobs awfully low. Like, is that just a function of this peasant blouse? But I don't know. I saw somebody in one of Suma's chats call them snake feeders.
For me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Prison bra. Okay, thank you, Super Kelly G.
We've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
Regarding the haircut, we have some discussion about the haircut in chat. I can't remember who, but somebody pointed out in the 90s a popular style was the wedge. And that's where you basically just cut off, a mane of hair to where you had that topiary look. And I think it was Ken Sukuroi that came up with a topi-hairy, which was a great pun on topiary. In any case, I think Sarah has been trying to recreate that. She didn't have it. Like in the 90s, she had the typical teased out puffy hair that everyone had in the 90s. But I think she aspired to that cut. She liked the pretty in pink, that Molly Ringwald kind of, and thought that she grew into it as she matured. But uh-oh, why is it frozen? Oh no. What is going on?
File is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is
Flock
the
of seagulls. That was a pretty. You needed to put a lot of work into the Flock of Seagulls haircut, and you knew you weren't going to come home looking good. Like if you had a fun night out with a Flock of Seagulls haircut, you're going to look like trash in the morning.
Okay. Give me 1 second.
Do your boobs hang low? Do you hang them to and fro? Can you tie them in a knot? Can you tie them in a bow?
All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471.
Thank God this isn't Juror 3.
Panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not
The
to
Dorothy
return.
Hamill. Thank you, Siba.
Juror number 551.
What was the first one?
Sure.
Who was the first
Juror
one?
number 471. Panel 3, that would have been yesterday morning, seat 48.
So this is just some housekeeping stuff, but somebody's got house issues. They're going to get dismissed for
Advised Jury
cause.
Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around.
4 cause.
The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is.
Blue Giraffe calls the haircut the Boone Bob. Buzzed Boomer reminds us that her Victoria's Secret bras are in storage with the heirlooms. Makes sense.
Planning on reporting today.
Hello, Meowgarita.
So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when 2 of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing?
Unless you want to say bless you all trial, if that's what you want, Mr. Kranick, you can have it, but I think we should use the bigger room.
Everybody in like sardines.
Response.
I don't know the layout of 23, so.
Can you all approach just for a second?
A little off the record. All right. Chance for us to talk. Leave it on full. I think they're going to come on to a full Sarah here, so I'll switch it to a ISO cam. There we go. But we'll put other things for you to look at, so you don't have to look at Sarah if you don't want to. But you certainly can. I don't think it's going to be a long sidebar here. The Boone Bob. Yeah, I think that's going to be the new name. We're approaching 100 in chat. Somebody pointed that out earlier. I made the mistake of pointing it out when I hit 100 in a recent chat, and as soon as I did, like 3 people disappeared. And I think that browsers are like, well, I don't want to be the 100th person. If this guy's excited to have 100. I am excited though. It's pretty cool. I really didn't expect ever to be live streaming to, crowds. But enjoy my parodies. The parodies, I thought that's what I came to the platform to do. I had a lot of fun with that. Oh, maybe I should go grab that. You know what? Give me a second. I'll go grab the lyrics to my Boy Named Sue parody. And as long as it stays quiet, I'll do a live reading of the latest Life Ain't Easy for a Gal Named Boone. I'll come back to that. And just talk amongst yourselves. Accidentally just flicked off the power. There we go. We're back. Kelly remembers when I got started. Actually, a little origin story there too. I remember my first. We're back.
Our court's going to take a 15-minute recess.
Thank you.
To address jury selection location this afternoon.
15 minutes will be all I need.
And to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the,
Thank you, LCB. Plainwell Mac, you've received a gift membership to Dandy True Crime thanks to LZB, her second gift of the day.
If he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct.
Anything in addition to
I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Said, let's see, is it really a 15-minute? Yeah. Okay, so we'll just, we'll let the court run, but I'll skip ahead. We won't sit through the whole 15 minutes, but I will use the opportunity, especially when they're ISO-cammed. Right, everyone else is going for snacks. Sarah has to sit. You get no snacks. You sit at the table. Yeah, no snacks for you. I was looking at this and I don't know, doesn't Wagner v. State say? Yeah, that's not what she was saying. Grandparents died. I was barely 43. Didn't leave much to George and me, except these old puzzles and a collection of tarnished spoons. Now, I don't blame George because he run and hid, but the meanest thing that man had did was climbing in that suitcase and give me the name Killer of Boone. Well, he must have thought that it was quite a joke and got a lot of laughs between each smoke, seeing him beg and plead to be let out soon. Sometimes I'd giggle at what I'd said, or I'd grab the bat and bust his head. I tell ya, life ain't easy for a gal named Boone. Well, I grew up quick and I grew up mean. My wits got hard, my lawyers keen. Yeah, Owens from Milton Town would play my game. I filled in my map tracking all Boone fan stars, but I missed Muldoon's and other bars. Drunky the Bear used to be my name. Well, it was Florida and Winter Park. We just got drunk and it was getting dark. George was dancing to a fractious tune. There in the closet towards the back, a suitcase sat with its zipper snapped. And that's how I got the name, Suitcase Boone. Well, I knew George wasn't gonna live, and it's on you was the advice I'd give. Recording every second for the camera's view. I was shrill and smug and mean and cold. I looked at him, my voice got bold. I said, my name is Boone, and this is a fuck you. Now what you gonna do? Shut the fuck up then, was my cruel reply, and he calmed down, but to my surprise, come up with 2 fingers and got 'em both right near. Then I smashed the bat right across his hand. I steadied myself for one last stand, then a swearing and a sipping on the couch with George in fear. Well, I tell you, I've been drunker then, but I really can't remember when. 3 magnums deep, Sunday style. So I've told you this and I've told you that. Nothing was intentional, except for the bat. Yet still I show up in court and smile. So Lowell's got me for an LWOP life, and best I can do is hope for a wife. Arts and crafts and maybe a phone call from outside. Why is this happening? I screamed and cried. The detective said it's because George had died. It was a good day and now I'm doomed. This is my story I'm telling you. Don't you all try to assume, because life ain't easy for a gal named Boone. All right. That was that. Little origin story was Classified Crime. Shout out to Classified Crime having me on for my first podcast. I was a guest for Third Rail had just come on the scene, and I was critical from the beginning. And, you know, whether you enjoy the content that's there or not, I'm not here to judge you for that. But I just initially, I didn't like the fact that it was edited, that we weren't getting the source. At the very beginning, they tried to pretend they were third-party documentarians who got these tapes from the people involved. And it's like, oh, you're the third party. Anyway, that's all besides the point. I was mentioning it in the chat on another creator, or in the comments on another creator's channel. Classified Crime said, hey, you want to come talk about that on the show? And I said, yeah, okay. And it went really well. And then she had me on another show, and I tried to be super funny, and I was like trying to jump in all the time, and it was just the timing was off. I had a terrible show. Somebody in the comments said something about, Dan, stop talking, you're not funny. And I was just like hurt. But then I decided, no, I am funny. I can be funny. I just have to stop trying. So that night I went and did a live stream that ended up, it was supposed to be just 15, 20 minutes. I was just going to do a personal live stream. Anyone who joins, hey, I'm just kind of working out, talking on the mic and getting used to looking at the camera. And am I okay? I'm still in the top window, aren't I? Okay, good. Anyway, that was the way that went, and it ended up going for 8 hours. We talked about all sorts of things, and one day we'll revisit it as a watch along. But it's amazing. Like, it's been just like 8-9 months, so same time it takes to gestate a child, and I feel like I'm a proper born YouTuber now. All right, here we go.
You ready? We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone.
Sorry, I'm just going to pause that there too. That you're ready? Let me just get a timestamp on that on my own video. Where are we? 146.50. I think pairing that little bit of you ready and then going into I sentence you to life in prison, putting those two clips together would be fucking awesome. There we go.
You ready? We're back on the record.
See, with that little smile, you ready? He's just talking to the court clerk, making sure that she's ready. But that would be, I think, a perfect jump cut. You ready? Life in prison.
2020 CF 2603, State of Florida versus Sarah Boone. State.
Thank you, Ken Tsukuroi. My mom said I was funny, too.
Defense.
Shout out to Mama Lola.
Ms. Boone is still seated at counsel's table wearing the same gray.
The one thing I'll say, and, to the commenter, I was a guest on another person's channel, and I get it. Like, if I have a guest that's stepping all over me, I could see some of you like, shut up. We came here to hear Dan. We don't want to hear you talking. So it wasn't as out of sorts as if somebody had come on my channel and said I wasn't funny. That was so out of sorts, I had to do my own dramatic reading of their comment and get one of my most viewed shorts thanks to their stay on your on rail
suit and white blouse from this morning. Can y'all approach?
Oh, approaching right off the bat. Same teal and white suit. See, now they're in different seats. Oh, look at that. She's just, what a great day. It's a good day to have a good day. But Chelsea and her partner, whoever she was in court with in the morning, something happened at lunch. Like, you know what? I'm just going to sit in my own pew. You kind of talk too much during the trial. I'm just trying to focus. Please let me maintain. Shoulder pads unite. And just for the record, these aren't shoulder pads. This is all Dan D here. Yeah. Yes, hee-haw. That is Chelsea in the gallery, and they have made a point of like, hold on, witnesses aren't supposed to be here if there's testimony. And the state's like, yeah, she's not testifying. She's just here. Well, is that allowed? Yeah. Yeah, it's allowed. Well, okay then. There's Sarah just filing papers. Oh, Mr. Owens, you got these all out of order. Here, let me just put these here inside my folder. And what else do we got here? Oh, we got another piece of paper. Okay. Well, I'll just tap, and get these at a nice right angle. And I'm doing such a good job. I'm wearing, look at those shoulder pads. Just jump in the shoulder pads. Just sit still, girl. Just sit still. Look at that. It's like she's wearing one of those neck collars for somebody who's gotten whiplash. little bit of shoulder. That's, stay tuned for the night show if you want to see more. There will be no night show tonight. It's my granddaughter's graduation. Shout out to my granddaughter for graduating high school. Shout out to all high school graduates out there. If you got a straight A's in high school, yeah, you knew I was talking about you. It's exactly who I was thinking about when I said that, Sarah. If you got straight A's in high school, don't stop improving yourself. There's still room to grow. Those shoulder pads are awful. It's like it's fallen out of the shoulder and like all the way down. Yeah, it's no good. Kelly, making a great point. The camera guy hates her. The camera guy's just doing her dirty. Phil for Dom Russo's pointing out that she's always chewing on her face. Yeah. I guess if you can't get blush, you just chew on your cheeks and redden them up a little bit. Roberta Real, thank you for sticking around. We'll be back on the replay anytime that you want to enjoy this. Sarah's still wearing her boobs low and her shoulder pads high for the second half of this day in court. Beth of a Salesman's here. Feeling a little natural joy. That's fantastic. Yeah, there's no way. I'm not fast forwarding any of this. All of this paperwork, folding, filing, this is all prime Sarah. I think if I do another Morgan & Morgan ad, like a spoof ad, maybe I'll have just this footage here of Sarah shuffling papers. Morgan, and Boone. No, she wouldn't go with Morgan, and Boone. She'd be like, no, it's Boone, Morgan. Do I have the date right? What date do I have on there? Original hearing. Yes, I think I do. It's a good question, but let me just scroll down. We're watching this on Law and Crime Network, and it says it was streamed live October 16th, 2024. The description says Florida woman, Sarah Boone, is accused of killing her boyfriend after she allegedly zipped him up inside a suitcase and left him to die. George Torres Jr. suffocated to death inside Boone's Winter Park home. Boone claims they were playing hide and seek. She forgot he was inside the suitcase and she fell asleep. Video evidence from the night of Torres Jr.'s death shows the victim inside the suitcase yelling for help while Boone records the video and laughs. Boone called 911 the next day saying her boyfriend was dead. She was arrested for second-degree murder. So yes, 16th, and I think we're going to watch the 17th before we're done today. Because there's no evening show tonight, I'm going to go along with the morning show. So we're going to watch at least up to the trial. We might even watch the trial. Day one doesn't actually start with the trial. It's still some motions, pre-trial stuff that happens before the jury gets brought in.
All right, court's going to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
So that's the plan for that. Beth of a Salesman's not drunk. She can't get drunk. She doesn't want to get drunk. Oh, that's a great point. Another one to say. She says she wanted a size smaller than what she takes, hence the bulky shoulder pads. That totally makes sense. So when the girls asked her for her size, oh, I'm an extra small. A 1, a 0 or a 1. And because of that, now she has this ill-fitting blazer because she's got this vanity about what size she should be. Great point. Oh, granddaughter graduation date. Okay. Yeah, no, that date is correct too. I can give a little bit of history on that. When I went to college, I met a girl in college that was, I guess, mid-20s, and I was barely 20, and we got together. She already had a daughter that was 5 years old at the time. We moved in together. I became stepdad. we split up, and I still stayed a part of her life. So, now I'm 50. I have a daughter that's mid-30s, and I have a granddaughter that just graduated high school. So, I'm blessed. It's nice because I get to, have a daughter and son-in-law that are both closer to my age. So it's just, I don't know, easy to relate. And like her son and I, my son-in-law and I, we play fantasy baseball together. So yeah, it's cool. But the best part is that I get to have all the trappings of fatherhood without ever having changed a diaper. So, not too shabby. What are we watching here? We're watching The Seal of the Great State of Florida. No, we're not. We'll skip ahead to. Looks like they get talking soon. We're ready, Mr. Kranick.
2603.
Okay, we'll just let them come back from here. Oh, yeah, no, the graduation is tonight, if that is the question, because I got that wrong 2 weeks ago. I was told about the graduation and was like, oh, can't do it. It's tonight. Anyway, we've had enough time for it to come full circle, and it is tonight. So, okay, I'll keep that in mind, Beth of a Salesman. Cloth or
we're back on the record.
Prepackaged.
2020 CF 2603, State of Florida versus Sarah Boone. State, let me get appearances.
William J. for the state.
Defense. Thank you.
Kevin Beck's always late on it. He's waiting for everyone to identify for themselves for the court. There was a previous time where he's late to the courtroom. Judge Kranick's not letting anyone slip by.
Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's fifth amended reciprocal discovery exhibit list.
Real quick, Disney Mom says, much respect for staying in her life, and I appreciate it, and at the same time, I'm really the lucky one. For any, I don't know, any guys that are out there that make an effort. If you've made a connection to the kids and there's, if you split up, but, they're adults and getting on with their life, there's a lot that, be a man. Reach out and, let them know that you're still there to be, the fatherly advice and, the whatever, the adult child needs from a parent. If you're a part of the life and you have a good relationship, that's it'll pay you back dividends by putting in that bit of effort at the beginning, because now, I don't know, now I've got so much thanks to just putting in the little effort to say, hey, I want to be a part of your life regardless of what happened, between your mom and I. So.
I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's fifth amendment was e-filed on October 3rd.
Okay, so this begins the no microphone at the defense counsel table. So I'll summarize if I can hear what James Owens is saying.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
So this is, I think, officially where we really cut off, or this is what we were skipping ahead to in the last show. So it's taken us that long to get to, but it's been fun. It's a good ride.
And Judge, this was a little bit of a
Okay, this is fine.
new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence
So this is, the state is bringing in all of this. Now, we know this is the rebuttal case. So this is, we didn't know at the time when this was being argued, but this is the, George, what are you going to tell them in court? You have 2 disabled dogs and you're you're not an angel, but, pretty nice person. So it's that video. It's the, it was a good day video. It was the, who the fuck are you sleeping outside my door at 3 a.m? I know how much vodka was in that bottle. It's all of those that state is trying to add here, and they're trying to eliminate.
The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant.
So what Mr. Henderson's doing is objecting to all of it. Just saying, you know what? I haven't had a chance to really look at all 119. I don't understand what all of these mean, so I'm just objecting to all of it.
So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to...
Remember the I don't have dates, because that shows us incompetence really soon.
The February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is
Hey,
laid,
Carolina,
that's
welcome.
my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay?
Response?
So remember, he's saying that he doesn't have dates. He's complaining that the state's evidence is just photos, and he doesn't know what's relevant and what's not. I think this is the part. So some people who, I think it was on Reddit where somebody was asking, like, I heard there's a part where Mr. J just kind of throws evidence at the defense. I think this is the scene they're talking about. And it's basically Mr. J saying, you know what? We've given you everything. For all the crap that you've given us, to complain about the way we're giving you information is rich. Phil, for Dom Russo, you're a straight A student. You know where this is going. Yes, happy Juneteenth, indeed.
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out.
So what he's saying is basically the Cellbrite gave you everything that was on Sarah's phone. He's made a CD of 119 files, about 40 of them that are going to be part of the main case, about 80 or 90 that are going to be part of the rebuttal case. And it's out of a complete deference to the defense. Hey, we know you're coming in late. We're not just going to give you the entire cell phone and you have to try and guess what we're going to use as evidence. We've narrowed it down for you. We've marked which case is which.
What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108.
That's your first clue of how robust the rebuttal is compared to the main case. The main case is George is in the suitcase. Sarah films it. Fuck you. Goes to bed. George is dead. That's the main case. Rebuttal case is she's a fucking liar. Here's another one. She's a liar. She's a liar. She's a liar. She's a liar. Here's more evidence. Here's more. Here's more. Here's more.
Attachments that go to the case in chief
Hey,
timeline.
Carolyn Ross. Good to see you.
Count up as 80 photographs and videos. Attachments and rebuttal.
Just a little heads up. I think we get some evidence. There's always been a question. Did she delete the videos? The cell phone videos, like the suitcase ones, did she delete them and they found them? Or did she, delete other content? Well, when it comes up, remember I'm bringing this up and I'm saying it so I don't forget either. But I think there's evidence that she did not delete the suitcase videos based off of what we're going to hear here.
Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and timestamp on each of those files.
So two things on metadata. One, and I hate to keep harping on Third Rail, but if Third Rail kept the calls in the digital format they were recorded, they would have metadata and they would have no problem releasing, we're looking for the call from September. Well, let's just look at the call from September. But they claim, we don't know. There's two reasons for that. One is they might have really been analog recording. So you're just using like an old magnetic tape as a way to get around the recording system if there was, something to block digital recording of prison calls. So anyway, that's a whole separate point. For Mr. Henderson to say, we don't know when these pictures were taken. You've got to have somebody in your office that knows enough about being able to look at the metadata for a file and see, the date is one of the simplest things to parse out of the metadata as a non-expert of, yeah. So just crazy to me that he would come into court and act like he doesn't know the dates of the evidence that the state is providing from her own cell phone too. It's not like this is special evidence that they've investigated. Like, this is Sarah's phone.
For instance, 12/25, 2019, 1:10 p.m. Another one.
So those are what the files are named. The files are named 12/25, 2019, 1:10. So a little bit of cryptography, a little bit of lateral thinking. Oh, that looks like a date. Why are all these files named 12/25, 2019, 12/25, 2016, 12/20, or whatever? It should have been a real clue if those were what the files are all named, the date they were taken. So, yeah. Metadata, okay, maybe you're not an expert. You don't know how to do metadata. The actual file name was the date. We'll just go back and make sure we reinforce that.
With all those files. So there is a date stamp and timestamp on each of those files. For instance,
hey, Silence of the Goats.
2019, 1:10 p.m. Another one might be 10.
It's an evening where Silence of the Goats is, so good evening to you.
26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this.
Hey, Mama Lola.
As states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? Right, that will received without objection as states 4.
So just to give the court an example.
Take your time, Mr. J. Oh, he's looking for an example that's not going to be prejudicial. He's looking for something that's kind of innocuous, so you can just...
On page 49 of 59 of the PDF labeled Case in Chief, entry 31107 in this PDF from the phone extraction is labeled Videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority.
Hey, Sharon. Welcome to the Fine and Dandy, celebrating a Bloody Keyboard membership. Keeping your fingers red. I'm glad to have you here in the chat.
Of these files, the ones that end up getting recovered from unallocated deleted space are sometimes not going to be there.
There we go. There we go. Okay, that's the part. The file names and metadata, all of that, are there for the stuff that was on the phone. The stuff that is recovered from unallocated space, so stuff that may have been deleted but still exists on the phone, because when you delete something, you don't actually delete it. You're just marking it as available to be rewritten over. So until it gets rewritten over, the file's still there. It's just waiting to be rewritten over. The fact that the suitcase files would have the metadata and information is a clue that she didn't delete them. She may have deleted other items, and he points out that those other items are part of the evidence, but they won't have the metadata. But I'm sure the suitcase video does. Let's just go back a couple of seconds, because I didn't understand what he was saying at first and then realized what I just told all you. So go back 20 seconds on that.
Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase.
There we go. So he says the image that he brought up, image 1062, blah, 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 and it has the metadata and this and that. And other ones won't have that data if they were recovered from allocated space. She didn't delete the videos. She was so fucking drunk. Her mind deleted. Oh, fuck, did I do that? Oh, I don't want to see that. It's that long? Oh, fuck. She didn't know.
That started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used. Video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother.
So Christmas 2019, this is 3 months before the incident.
Having a conversation with Sarah Boone, the owner of the phone.
Sorry, 2 months. Yeah, because if it's Christmas, then you've got January, 30 days. This is 2 months before.
Culminates in hide and seek, I shall. That's the context of that conversation on
I'll get rid of them, hide and seek. Yeah.
Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text.
Great point, Kitten Pusher, responding to Carolina Hurtado. That is interesting about cleaning up the crime scene. Maybe the whole cleaning with George for a sense of accomplishment never even happened. She cleaned up after the murder and then added the story of, oh, we cleaned up for a sense. So now there's a reason why it's recently cleaned up. Oh yeah, we just cleaned up yesterday.
From the owner of the phone saying, and bless you and all of you too, I'll get capitals rid of him. So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is...
Okay. The chat's getting really interesting right now, and I just had a thought that I've never thought before. Do you think that the suitcase may have been a regular punishment place for George, where Sarah would, like, you know, get in the suitcase, I will beat on the outside of it with a bat, you won't get hurt because the suitcase protects you, and this is how I'll get out my frustration with you. Get in the punishment suitcase, George. Because the I'll get rid of him and hide and seek I shall. And the way that in the interrogation, no, we've never done this before. Like doing it before is some sort of, she seemed like that would have made her feel like more guilty. Like, no, we've never done that before. And Scott said, well, why did you say it like that? Because we haven't. Well, why did you do it this time? I might have to flesh that out, but thank you guys for giving me something to think about.
Again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child.
That comes up. We'll just put a pin in that.
Any of that child's friends, there was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art.
That's key. And Mr. Henderson's not listening right now because, so he's explaining, you know, 80 pictures. There might be pictures of, or there might be a text message, oh, George is beating me, George is this, blah, blah, blah. And then it's followed up by a picture of some artwork they just took. The artwork in itself isn't relevant, but the fact that she's taking pictures of artwork rather than in the throes of tragedy when she's texting about being in the throes of some sort of personal tragedy, it gives you context to the fact that, you know, oh, well, maybe things weren't as bad as you thought if she's framing up her pictures of artwork instead of, you know, taking evidence pictures or whatever. Anyway, he I think makes it very clear why the art's relevant, and then we'll now listen to Tony Henderson. I don't understand how a photo of art could be relevant.
So We did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes.
Hey, Pine Weaver.
We believe
Aaron?
will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason.
And that's the problem, too. They just objected to every piece of evidence that they're bringing in there rather than saying, you know, well, file 12 and file 48, those are irrelevant. We don't want those.
We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd.
Some discussion about how Child Protection Services visited Sarah because she posted a picture on Facebook of her son in the suitcase, some sort of, we're going to Disneyland post. But she was visited and told that, that's very dangerous, don't do this. And that could have been another little piece of information that just got filed into the back of her brain as, I never thought of it as something that could be dangerous. I will keep it around. That'll be my weapon of choice. But yeah, Kitten Pusher's comment is, when son was put in the suitcase and Child Protective Services was called, do you think they ever said to Sarah, someone could suffocate in a suitcase? So yes, 100% she was warned and knew it was lethal. And, straight A student she is, she filed that information away and used it at a time she thought it was appropriate.
98 from the Second District Court of Appeal decided in 2021.
Yeah, Aaron lives here. That's exactly it. Objection, Your Honor. What's the reason? It's devastating to my case. Overruled.
Lambs versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well from 2017. The basis of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction.
Actually, and regarding that, I'm going to take a look in the background, but regarding suitcase danger, there was just recently a news story from Morocco. Gentleman tried to smuggle himself in a suitcase to get a free flight and died in the suitcase in flight. We'll see if I can find some info on that.
So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone could be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the Confrontation Clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, what has had some discussion.
The little look she gave, like she even understood what any of that meant. Like, that sounded negative.
Since the Crawford decision was, what's hearsay versus testimonial hearsay? Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution.
I think she wrote down Crawford versus Florida, and she's going to make Lana look up Crawford versus Florida. Fucking shoulder pads are so bad.
So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we...
That's a great point, Kitten Pusher. I think Owens told her to take notes on everything. He doesn't really need them. He just wants her out of his way. It's the same way like you'd keep a child busy. You know, hey, I need these blocks stacked. Nobody can stack them properly. You're a pretty good kid. You're smarter than the other kids. Could you just stack these blocks quietly while I'm on the phone here? And yeah, if you get them all done, I'll give you a cookie or 5 peppermints and a Pop-Tart.
Provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. Can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates.
See, so that's it again. Some were from unallocated space, but he kind of made clear that the suitcase video had all of the metadata, had all of the proper file names, so she didn't delete it. And I just discovered it on the rewatch I was doing to prepare for this show. Yeah, this is 2 years after the trial.
Corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury.
Hey, Margie.
So that the state can pull any photographs or videos, or we can have at least a discussion about those specifics, and then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you.
Thank you.
Response.
Mr. Henderson, why don't you just let us know whether you were listening or not listening to what Mr. J had to say?
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos.
Phil for Dom Russo, that's Shelby Andrews, I believe you're referring to, girl A of the girls. But yes, Shelby Andrews is the juror expert and one of the two beauty experts that helped bring the Sarah that you see before you today.
Examples.
Hey, Dor.
What's the use of this photograph? There's a piece of art on the wall.
What's the use of this? There's a piece of art on the wall. How's that relevant? Would have been great if Mr. J just explained how that might be relevant, but
I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. Correct. It is objections to all cell phone video evidence the state intends to introduce.
Mr. Henderson tells the judge, no, you're wrong. Judge gives the receipts. Mr. Henderson follows up with, you're still wrong.
To the lack of specificity.
And welcome to the chat, Kevin Brady, fellow Canadian. Also probably made a little merry yesterday after that 6-0 shellacking of Qatar.
That these are just boilerplate objections.
Let me see what
to
I can do.
all photographs, all video.
Court audio low?
Yes, well, they're not to all photographs and all videos.
I can boost it.
There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. Correct. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case. Or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is at that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those.
But you did.
Do you know why? It was clear. I know when it was, and I know the purpose of using it.
But you did.
But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it.
Correct. But we're not objecting to the suitcase, but it says you're objecting to all. Correct. Do you even know what you're saying, Mr. Henderson?
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
No, it doesn't.
The
Welcome to the chat, Ramono. Glad to have you here.
suitcase video is listed in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well,
That, we're going to listen to that again, too. This is basically Mr. Henderson kind of, okay, look, we don't know what we're doing here. Just tell us what to do, Your Honor. Please. Throw me a frickin' lifeline. 15 seconds till we get to the part that I'm highlighting.
Things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well,
How does it need to be done, Judge?
what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not?
This is Judge Kranick's I've got a pair of aces face. If you're playing poker with him, he'll cover up his mouth and do this sort of lean so that he's giving less away, but he's sitting on aces. He already has all the facts. He knows what's going on here. He's not trying to figure out what Mr. Henderson's saying. He knows Mr. Henderson isn't saying anything.
Not been laid in court for evidence being omitted.
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So
Then
I'm not going to
Hey,
address
Carolyn.
foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem
Okay.
with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
What the hell are you talking
Okay.
about?
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's.
And so what I think is happening here is Judge Kranick's going, well, that's not the case, but it's also not for me to give you legal advice. So while he's prohibited from doing it for a pro se defendant, because then he'd be possibly biased in the case, he's choosing not to educate Mr. Henderson here. He's like, okay, if that's what you think. Anything else, Mr. Henderson? But he's deliberately just letting him, he's just giving him rope is what he's done.
Because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I
Anything
know
else?
it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
So again, that's him. He's trying to ask for advice. He's like, look, I'm not from the district. Please throw me a frickin' bone.
The reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se.
Mm-hmm.
And we needed to establish deadlines
Yes.
to prevent any ambush or last minute issues. Then y'all parachuted in on August the 30th.
Y'all parachuted in. You did this. You didn't have to be here. You chose to be here. You knew what the case was. And now you're complaining, oh, we've only had a couple weeks to prepare. You knew what was happening.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things.
And that's the thing. Like, why are you even talking? The state explained the artwork is relevant to the fact that she might have been complaining about being beaten the fuck up or getting ragdolled. And then 3 seconds later, she's, showing herself doing scripted, live, laugh, love posters.
We well know the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a
RN2 Mums loves the picture of the Kintu Sukuroi statue of Sarah. I've got to give full credit to Paul Clank, NYC. He has his own YouTube channel. He created that as a design of his own. Sent me a copy. I think it was funny, and I did think it was funny. But check out Paul Clank NYC's channel if you're interested in. He's collected a few news clips from the time of the trial, so like 2020 news clips of local radio or TV stations reporting on the Sarah Boone thing. He also has a clip of an interview with Eli Walker from the famous Kim and Eli. Eli and Kim. So check out Paul Clank NYC. It's all one word. PAULKLENK NYC. And don't let the NYC fool you. He's from Tennessee.
pretrial ruling, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications?
I understand. I know what you're worried about. You have no reason to worry about it because I just told you can still object to stuff at trial, but...
Questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase.
This is
then,
great.
That person's going to have to testify, well, I gave it to...
Okay, so here's a little lesson. We'll just go back a half second. If you've ever wondered how a foundation for evidence is built in court, Mr. J is going to give us a little TED Talk on how evidence foundation is established. Take it away, Mr. J.
To go back and pull out pictures and pull out videos or black out lines or
Thank you,
remove
Kelly.
pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be...
Here we go. Okay. This is how foundation for evidence is laid at trial.
The law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment.
So we'll see this in day one. The CSI who walks through and took photos of the crime scene. What's that on the counter? That's Miss Boone's cell phone. So they can establish chain of custody. We came in, the cell phone was on the counter. CSI took that cell phone that you see in the picture, gave it to Chelsea. Chelsea got password from Miss Boone. That gave access to it.
Right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, This is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day.
He's a little dismissive. This is the phone I plugged into my Magic Cellbrite software. But again, this is exactly, you don't just bring in evidence. You have to establish that it is evidence that, you know, how is it relevant right from the crime scene to being here in the court today?
And this is how Cellbrite works. This is my educational background, blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, you know, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
And I don't think there is a rule that bars you at this time, but...
Okay. I'm going to overrule your objections.
Love it. I love it. Just, okay. Yeah, you've made your concerns clear. They're stupid, but I hear them.
At that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay.
Okay.
I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
Yeah.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
Boom, boom, boom. Okay. So you hear that. The state's proffer said there was no photos of the child. That's not correct. There are photos of the child. This is 2:23:26 of the video. They take entirely too long to get to what the photo is. I'm going to have enough time to set up a poll and ask you what you think the photo is.
That are being sought into evidence?
Yes, Your Honor.
State?
Response, if any?
And now the state is, you can see Mr. J rapidly going through his computer trying to find a picture. I don't think there's a picture. Just this quiet search of like, that doesn't look like him. That doesn't look like him. All right, 3 options are up.
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
Hey, Michaela. Exactly, Kitten Pusher. Why not just name the picture? Like, look at file 9415. But no, they're not going to say that. You'll see Shelby Andrews has to come in. She's looking for it on the computer. And she's going to come in and sit beside Mr. J. And then Mr. J is going to go back to his own files. And, yeah, they're taking way too long for this. Has everyone had a chance to vote? There are some straight A students here. I can see the vote is going. We've got how many votes in now? Oh, that just lets me end it. Okay, we'll let you guys still vote. But yeah, just silence in the courtroom while everyone's going through 119 pictures. With Mr. Henderson just saying, no, that's incorrect. There is a picture. Like, just tell us. How much time have we wasted on this already? So 3 full minutes. Mr. J sits back. He's like, there's nothing. I can't, unless they tell me what the picture is, I don't know. So what it probably is that Sarah looked at all of these and was able to figure out, like, oh, well, that one. And I think when this first happened, my impression, okay, there, Shelby's found it. Shelby, go show Mr. J. I thought it was probably like a photo on the wall, like, you know, so it was a picture of, you know, the kitchen, and you don't think about, you know, the grad photo on the wall or the grade 7 picture or whatever. And Shelby just, so she came over, showed him, and then Mr. J doesn't want to have anything to do with her.
2 images. I couldn't recognize it as reflection of children.
There we go.
I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those 2. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
I recognized it as a crab.
Well,
I'm sorry, Judge.
Extraordinary file name, but I'm going to remove those 2
Okay.
exhibits that they're
I'll take care of that issue for you.
So yeah, she might have taken a picture of, you know, her goldfish in between, you know, complaining about domestic abuse. So it was relevant to the fact that, you know, well, who takes a picture of their goldfish if they're complaining of domestic abuse? And maybe son was sitting there beside her. So when she took the picture of the goldfish, there's the reflection of the faces. And he's like, fine, we don't need to use those.
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that, and why I raised it, is that there are going to be certain things that I'm not going to know.
And now he's going to try and like piggyback on that. Like, so now, Judge, you see, you know, we didn't know the reflection was in that photo. Who knows what's in the other evidence? I need to reserve the right to object.
And 2, what is the purpose of it as far as how is it relevant now?
It's a crab in the bucket.
They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
Okay. All right, thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits?
Yes,
Mr.
Kitten
Henderson?
Pusher, 100% said it.
No, Your Honor.
Okay. Moving now to the defendant's 5th amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I'm not buying it has me on pause, so we'll just all pause for I'm not buying it. All right, that's enough of a pause.
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel?
That's fine.
All right, is that acceptable to the defense?
Yes.
Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
All right, we're going to stick around because we get to watch Sarah get reshackled. We don't want to miss that. The shackling of Sarah. There is Officer Pink Cuffs, ready to resume her shackling duties. Mr. J having a little word with Chelsea. Mr. Cacciatore going out for some lunch. Sarah organizing. Oh, she's so organized. You got to keep all those folders in the right spot. All right, Mr. Henderson taking his file folder away. Yeah, get in the chair, that green chair that doesn't move. That's your chair. You don't get the chairs that move. Those are for free people. Where's your red folder? No shout out to Lana today? All right, here we go. Shackler. See, yeah, that's a well, I guess you'd call it low-hanging fruit. Making fun of somebody's appearance, but something's low-hanging there anyway. All right, everybody off to enjoy their free world food. Sarah getting delivered to the basement for her peanut butter and jelly sandwich. Here's your paperwork, Miss Boone. Thank you. Thank you. It's very important. I'll just review this over my lunch break. All right. Bye-bye, Sarah. I think that's all we have in this video. Yes. Yep, the rest of it is the static pattern, so we will skip to
Sarah.
We will turn down the volume a little bit because this is a little fun. So I've usually skipped over the analysis of this part of it, but we're going to do a reminder of the snacks motion because for whatever reason, the snacks motion, you can see she's wearing a green collared shirt. All the trial coverage I can find, I can't find this particular day of coverage. So the only way we're going to get Owens making the snack motion is through this. But now I've watched the analysis enough times that I can comment on the analysis. We'll enjoy this whole 11-minute video from Court TV about her snacks.
Boone in
But it's loud. It's loud. Let me just turn that down just a touch.
court to the suitcase murder trial. Trial not opening up just yet. They're still working on getting that jury seated. They started on Monday. They're going to continue today. They have a motions hearing set for 9:30. Apparently still some outstanding motions. And then they're going to continue picking the jury in the afternoon. And in case you didn't hear, Sarah Boone filed a motion requesting snacks at her trial. And so we're going to get the answer from the judge this morning about that. Take a listen.
Yes, sir, Mr. Owens.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning, and then of course she's brought up around 9, and then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that...
Kitten Pusher, sometimes because I do have so many mods, it's very possible that there's the occasional comment that gets accidentally deleted from just a moderator, double tapping something or something like that. I don't have any words excluded from my chat, so... yeah, I see your comment now, though, that the dehumanizing and chained look of Sarah is, well, it certainly can be commented on. So, by all means, put your dehumanizing and comments about chains in the chat.
They get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs.
Ooh. Sorry. Keep interrupting. There has been occasional YouTube issues where you post a comment and it just disappears. It's not common, but I remember having that issue a couple months ago. I would just put in things and they would show up as being in there, but then if I switched from all messages to top, all my comments were gone, and it kind of explained why nobody was responding to them. But yeah, occasion, just try and refresh maybe, cut out and cut back. We'll go back to the request here.
For 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart.
Either cookies or a Pop-Tart. I'm flexible. I'm up for solutions.
To allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
State, any response?
Not from the state attorney's office and any of the parties involved.
Okay. I will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are...
I love how quickly the court clerk brings, they get fucking sandwiches. The clerk is so quick. There it is. Judge, she's getting fed.
Promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials.
Inmates that are stored downstairs. Very dehumanizing to be stored.
So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
Thank you, Judge.
All right, anything else?
This woman is on trial accused of committing a murder, and she's concerned about her snacks. Snacks. She's not going to the movies. She's going to her homicide trial. And she's being specific. She's going, I want, 5 peppermints. I want to have a Pop-Tart or some cookies, 2 bags of potato chips. Get real. This lady's unbelievable. What about the sadness she might feel for her boyfriend, George Torres, who lost his life? He doesn't get to eat anything. And by the way, the jail is sending over meals for her. My understanding, 2 meals to be sent over. So it's not like this woman is starving. She just must think she's special. Let's bring in our attorney guest to talk about this. Very seasoned trial attorney. He was a homicide prosecutor, Randolph Rice, on the program today. Randolph, can you believe this lady? The nerve with her.
No, I
Yeah, spoiler alert, Randolph cannot believe this lady.
can't, and this seems to be consistent with what she's been doing since the beginning of this charges. Remember, she's been, and we've talked about this for a couple of months ago, she's gone through, 9 lawyers now, and this seems to be consistent with what she has done leading up to this point. I guarantee she had this conversation with her defense team. They probably told her, no, we're not going to ask the judge that, and she probably pushed back, and they thought, you know what? Just to cover ourselves, we're going to ask the judge, as crazy as it may be. And I guarantee you this, the defense attorney was embarrassed to ask for that request. When he turned around, he looked like the most embarrassed person in the world because he knew how silly it was. He knew how ridiculous it was, but he still has to do what his client is asking him to do. And here we are with another crazy request from Ms. Boone.
Yes, Randolph, you're so right. You said what we are all thinking, that attorney would never want to ask those questions of a judge. Would never think of that. But because he's got a bossy client, he did what she probably pushed him to do. I think your analysis is spot on. Here's another clip I want to show you, Randolph, where she's probably pushing for more outfits. She's very concerned about.
So we did see this one. This was the motion for the Glam Squad. And that's why Shelby Andrews and Lauren Henderson are part of the legal team.
How she looks, we know that she wanted a glam squad. She wanted a professional hair and makeup artist, to do her hair and makeup for this trial. I mean, it's incredible to me. Let's listen to what her lawyer said to the judge about that.
She expressed, it was a 2-week trial, she wanted to wear something different every day. They expressed to me that if I would just bring her clothes every morning, whatever she wanted to wear, and then pick them up in the evening, the clothes she wore that day, that would work with them instead of going to the visitation center and that whole process. So I think that is probably the way to go.
Okay. Well, then that saves the phone call that I had set up with Captain DiGiovanni at 12:30 today to try to figure out what the issue was with the clothing.
Is always an issue with her, Randolph, as you know. Would you speak to how things typically go when you're getting a client ready for a trial and if they're being...
Well, first you take a careful record of all the snacks that client is interested in having.
Held in jail prior to the start of the trial. Certainly there are challenges. We acknowledge that. Would you kind of speak to what's normal in the process, Randolph?
Sure. So each jurisdiction is different, and it depends on how the sheriff's department or the department that controls the jail and does the transport deals with each inmate. Some departments would rather have the attorney bring the clothing or the family member bring the clothing to the jail, allow the defendant to get dressed at the jail, and then transport them that morning in the clothing.
See, this is a weird look for her, too. This is like Sarah's hot mess look. Again, with the ill-fitting shoulder pads, those are terrible. The big Brady Bunch collar, ill-fitting green shirt that matches the green chair that doesn't move.
Some jurisdictions, the sheriff's department, rather the lawyer bring the clothing. And obviously all this stuff has to be searched, right? Because they don't want things from the family maybe being snuck in. So that there are security concerns that they have about checking the clothing, make sure that there wasn't something put in there by a family member.
Was she putting on her shoes there? She's sitting there bare feet. Ugh. I think she was putting on her shoes.
They have about checking the clothing, make sure that there wasn't something put in there by a family member.
That might have even been the bailiff. You put your shoes on, we can smell it. I'm standing at the back of the courtroom, Sarah. Your lawyers, just do us all a favor. Put on your fucking shoes.
So it is a lot for the sheriff's department or whichever the police department that's handling that transport to deal with this every single day. It is doable, but it's a lot of work to add on top of, remember, she's not the only one in that courthouse that day. They're bringing other inmates over. So it's not the Sarah Boone show. It is the sheriff's department having to bring multiple people, and she's probably gumming up the works with all of her requests.
Oh, you're so right, Randolph. You're so right. Can you imagine her in the transport van?
Exactly. And she's sitting there all smug in the transport van like, oh, you guys are all criminals. I have a snacks requisition.
Because, that's the way it goes for our wonderful courties. There's a big van that goes from the jail, multiple trips sometimes, and you have multiple prisoners in it. As Randolph noted, it's not the Sarah.
Thank you, Carolina Hurtado. I almost missed that. Bedtime Lullabies has given 5 gift memberships to Dan D True Crime. And I just need to go back to find out. Oh, there it is. This is Forever Wander, Jane Crow, Shields for You, Lydia, and Lolly. All of you have received gift memberships thanks to Bedtime Lullabies JLC. Thank you very much. Getting back to Randolph.
Boone show, although she'd like to make it the Sarah Boone show. I wonder what those other inmates think about her, what they're saying about having to spend that time in the van with her and hear about these crazy requests. Oh my gosh, I bet.
Can you imagine, like, inmates are comparing notes, how's your trial going? Oh, well, my lawyer's pretty good. I'm hoping for the best. And I've got a motion in for 5 peppermints.
They have stories to tell. I have another clip I'd like to play for you, Randolph, and this is where her attorney, if you recall the other day, the judge was asking about the defense witness list, and Sarah Boone threw her excellent counsel right under the bus and said, I haven't seen the list, and I'm not agreeing to it because I don't know what's on it, and really made it seem like they haven't communicated. And we know James Owens is a very seasoned attorney and has communicated with her, and so here.
Seasoned is a polite word for that. Yeah, he's a seasoned, little salt and pepper.
Fast forward to the other day, she finally agrees as to who is on the witness list. Let's watch.
Forgive me, Your Honor. Could you please repeat the question?
Sure. The question was, without going to any specifics about conversations that you've had with you and your attorneys, are you in agreement with the persons that have been identified in that list that may be called as witnesses in your case?
I'm not familiar with everyone that's on here, but I do agree with whoever it is that they have on here.
Okay.
Ooh, okay. Randolph, she's, what do I want to say? What's the expression? Dumb like a fox, right? She kind of played a little dumb there about, well, I don't know who's on the list, but I guess I agree. Do you think she's trying to set up some kind of post-conviction relief for herself?
And I'm just going to save Randolph the time, but I personally don't think she's that clever. I think she knows by not committing to anything, she can always adjust the story later. So I don't think it's as much a planned strategy as a life coping thing where she just doesn't commit to anything knowing that she's going to talk her way around it when it comes up in the future.
Ineffective assistance with some of these comments she makes.
I certainly think she is. She is probably trying to lay the groundwork for either a appeal or some sort of complaint against her attorney saying that they didn't provide me this information. I never got to look at it. And that could certainly be a basis for an appellate court to look at this case and say, well, you know what, we need to give her a new trial. She's being very sly. Again, this is the Sarah Boone show. She thinks she's smarter than everybody.
And just for the record, this is prior to the trial. So when this lawyer is saying that, maybe it's going to give some deference to her appeal, he's just speculating prior to the fact. Like, this is before the trial even took place. So don't listen to him and think, oh, is there an appeal? There is, there is an appeal that's filed, but it doesn't have nearly the merit of even the argument he's discussing right now.
Somebody else. And so I certainly think she's being cryptic. I think she's maybe trying to be a little difficult, which, look, she's going to be difficult through this whole trial. There is no doubt about that. So, with the food requests and the clothing requests, and by the way,
Disney Mom, you might have a problem that's that's entirely unrelated to the humor from Charles Grieve. You might need to just look into a, at least Scotch guarded chair anyway.
Julie, do you have any more Pop-Tarts? Could you send some to me, please?
Yes. Yes, Randolph, absolutely. You deserve all the Pop-Tarts. You're one of our favorite legal analysts. And gosh, I know, I wish I could, send some through the television to you right now. Yeah, we should get snacks, right? We don't snack, we do our jobs. That's what we do. My goodness.
Liar, you guys snack.
Do you think the judge, before we hit a break, do you think this judge is going to grant this request? Because at the end of the day, it's in his hands, as you know. What do you think?
Yep, Carolyn.
No, this judge seems to be a no.
It's in her nature to be difficult. So if there's, an easy yes or no answer, she'll find the difficult, meandering, long-ass answer that answers neither.
Nonsense kind of judge. He's going to call it right down the middle. Remember, judges are there to call balls and strikes, and they're going to take the law, they're going to take the current rules that have been set up by the courts, and they're going to say, look, I'm looking at what you presented to me. I'm going to look at the facts. I'm going to look at the law and what the courts have said, and I'm going to make a call here. I'm going to make a balls and strike decision here, and we're going to make it reasonable. And so I think he's going to make reasonable calls, but I don't think he's going to put up with her shenanigans as this trial proceeds.
Mm-hmm. Right. And we know she doesn't have a medical issue of low blood sugar and doesn't have a need to have candy or juices there at the desk. And the jury's not getting it, right? The jury's not getting snacks to munch on. So why should she?
Hey, Julie, 2 hots and a cot. That's what we always say, and that's what you get, Trust me, the sheriff's department is providing plenty of food. It sounds like she's getting a peanut butter and jelly sandwich, and it sounds like she's even getting cookies. I don't even get cookies during my lunch, so she's doing better than we are.
We got to talk to somebody about that. We got to get some cookies for Randolph Rice and some Pop-Tarts. You're the best, Randolph. Stand by kindly, if you would, please. We're going to hit our first break of the hour right.
Okay.
The court minutes.
So that was fun, and that was the court TV reporting in between these two shows, or these two shows, but these two streams being broadcast. So now we're moving to the October 17th, 2024 stream. This is the day after the footage we just saw. Let me just adjust my chyrons. Have we got play? We do have play. Take off the top chat. Are we playing it slow? Nope, normal. That's good. Oh, we get to skip ahead quite a bit. Yeah, there's 40 minutes just saved. That's a great thing about doing a trial rewatch as opposed to live. Live, we would have all panicked to be here on time for the feed to start, and then we would have sat here for 42 minutes waiting for people to come into the room. No, we don't have to. We're busy. We have things to do. Not like Sarah. She has endless amounts of. Okay, there we go. In walks the crime. In walks the crime. Yeah, we should come up with a Here Comes the Bride parody for her. Oh, Lauren and Shelby are they're giggling. They're having a great time. Oh, hi. Looking good, Sarah. Love your hair. I see the defendant sitting before me in a brown blazer and a piss yellow top. It was a white top, but it was sitting underneath of Disney Mom when she was reading Charles Greaves' comments, and that stained her blouse a lovely urine color. She pray forgiveness. I'm sorry that it smells like urine, guys. That's just the shirt they gave me. No, we don't need your help, Sarah. You're not allowed to touch papers. It's a lovely pinstripe outfit by Lauren Henderson there. Always loved the look of pinstripes. Old school Yankees fan. The original song was called Mark of the Whores. Mark of the Whores, Mark of the Whores. Huh. If it wasn't, if you're just trolling me, I'm going to remember that now. And then, so she gets the girls to fix her hair, and immediately, look, Sarah, it wasn't like your hair was fixed, but whatever they did, you just undid in 3 swoops. They're looking at you. They know how stupid you look. Okay, still wearing the boobs down low today. It's definitely not a wonder bra. Oh, as the American game started, to anyone who is a American football World Cup fan, I understand if you need to minimize me, put me in a little side window, or just come back on replay. Yeah, it's happening now. Yeah, if you're from the American continent and want to cheer on your team, I totally understand. I couldn't even do my own stream when Canada was playing. Well, I did it for about 40 minutes until I realized I was doing it. But can I have a pen, please? No, you can't have a pen. Pens are sharp. You're here for murder. Well, thank you for giving me all this paper to shuffle around. Now that I've got this sheet and this sheet. Have you got sheets like this? Yeah, I've got all my own sheets, Sarah. That sheet there we just gave you to keep you busy. These sheets here, they have all the evidence. How come we don't have yellow legal pads like the state?
William J. for the state.
This is... So their microphone isn't working today. So all we've missed there was James Owen for Sarah Boone, Tony Henderson for Sarah Boone. Wherever I can, I will re-say whatever they're saying. I think we've got them on as much of a boost as we can.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse.
If you didn't hear that, Sarah said Sarah Boone 10-10-7-7. How did he describe the blouse? Not piss yellow? It's disappointing.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse.
Just yellow. Look at, she even makes that little face like, yeah, I wouldn't have picked yellow.
She is in custody. However, she is not being shackled.
And the defense microphone's not working. Sarah got some kind of EMP, she destroys laptop batteries. The TV was broken. That's why George had to break it with the bat. I think Sarah just ruins electronics. And the microphones are yet another victim of Suitcase Boone.
For the purposes of the trial, based on the court's prior findings, we're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit.
Oh, right. It's USA versus Australia. Oh, my. That's quite a battle. I'm not going to pick a side because I definitely... I've got people rooting for both. So I just am rooting for a good game and that nobody breaks a leg like in the Canada game. My God. Horrific.
List. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, State, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating you to type a written.
Okay, that's what I wanted clarification on.
So this is a bit of a delay. We'll get back to the motions in limine. But that's, again, so Mr. J needs the clarification for this, both for his opening arguments, but also for how it's going to impact his ability to object to Sarah's team's arguments. So you can pause it if you're on the replay, or if you're live, you can pause it and read that. I've read it once before, but just basically a motion in limine clarification that Mr. J needs, and we'll skip a little bit. It's about a half an hour before it gets there. Back to the court. Oh, that's actually a good view. Let's do that for a bit. Oh, and play.
Thank you.
But I just do want crystal clear clarification as to what we are both doing, because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
Yes, Disney Mom, that is the Glam team.
You did not.
That is Shelby Andrews and Lauren Henderson, who have been conscripted
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So Digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you?
Look at that little smile. He knows, like, I'm asking a lot. I'm sorry. Do you mind doing it? I love how deferential the judges are to their court reporters. When I was covering the Betty Broderick trial, that judge was also very like, no. She's the brains of this operation. Good for the judges that take care of their court reporter and realize how much work they're having to be put through.
Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statements when I don't know what I can say.
And that's exactly. So we'll get to a better resolution than what's happening now. But Judge Crane agrees 100%. Like, yeah, you need to know before you make it. But what do you want me to do? We did it yesterday, and I don't have it printed out for you right now. I think, we'll let it play. They come to a better solution.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box. But
I understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay. Well, then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson is going to take a minute. I guess we start at 10:30 or 11, and that's going to spill until probably late afternoon before we actually get a jury pick. Can we just agree on Friday morning starting opening statements? That gives her time, him time, me time.
State?
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half, 2 tops.
Okay.
And then we've got each jurors pause and preparatory.
Correct.
I believe we each have 10 strikes.
That's correct.
So that's going to take.
Okay. Mr. J?
So if you missed what they said, they're
ruling so that
basically they're just talking about how much time they need for asking questions of the jury, which we're not going to end up seeing anyway.
with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday, and we could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right.
Solid
Madam
argument.
Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Sure. Okay.
There we go.
All right, then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State, or Mr. Owens?
30 minutes? Excuse me? No, not that long. Okay.
How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir.
Excuse me.
Yes, sir.
One thing, because there was another motion filed last night.
Yes.
I think it would have some impact.
Okay, he says, so there was another motion that was filed, and I think it may have some impact. Shelby Andrews over Mr. Henderson's left shoulder, and Lauren Henderson over Sarah's left shoulder. Right shoulders. It's about the opening statement. If we narrow that down.
You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Correct. Fine.
Correct.
And just to make it quick, Judge, I've read the motion, I've read the case law that was provided by the state.
Judge, just to make it quick, I read the motion and I read the case law that was provided by the state.
Okay.
And I feel the exact same. Okay.
Well, that saves me some time then, so I appreciate that.
So he's agreeing with the state. There's no objection. Okay, perfect.
All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial?
No objection.
All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Off the record. All right, we've got 15 more minutes of our life that we'll save. We're going to stay here as long as the camera's in on Sarah, but we will use our trial rewatch powers to magically move ahead in time when that time comes. We'll just sit here and let Sarah sit with the enormity of her actions. Yeah, chew your face a little bit. I bet it's eating you up from the inside, isn't it, Sarah? Well, it's a very nicely tailored pinstripe. You can see that you've got like the little V's in the backs of the jacket so that the pins are able to run parallel, but they also don't cut weirdly into each other. That's a lovely coat. Hey, Bernice Conklin, I haven't seen you here in a while. Welcome back. Remember Bernice Conklin from the Betty Broderick trial rewatch days. So it's good to see you here. Okay, let's just get 15 more minutes of our lives back. Skip ahead. Boom. The magic doop-da-doom. Aussie, Aussie, Aussie. Oi, oi, oi. Okay, there's the team. Let's go back just a second. Excuse me. Hey, Yasiba. Billy Lane there in the background of court. Shelby Andrews in the gallery, Lauren Henderson in the back row, James Owens, Mr. Henderson at the table, slices of bread and a Sarah Boone sandwich. Kevin Beck also sitting in the back row, just off camera. Hey, Ian Webb. I do like that, narrating golf feel to it. We've got Kevin Beck approaching his ball. He's testing the wind. Lauren Henderson has handed him a sand wedge, which is curious from the green. He's rejected the sand wedge, and he's moved back to a proper putter. He's got this. He's got 2 shots to make this to win the match, but sometimes these 8-footers, they can get a little surprising. You never know what's going to happen. Sarah busy making notes. She's got her pen. She's got her paper. Shoulder pads sticking up probably 3/4 of an inch. Maybe. Oh, hold on. What is that? Is she drawing pictures? Oh, no. She's studying. She is studying. This is a power and control wheel. How much of that can you see? You guys can kind of see it. Power and control. She's studying. Well, straight A student Sarah is. They've handed her some documents so that she can look up, or so that she can practice what a battered woman does. Put that back down, Sarah. You don't want that to get on camera. I just wanted to show you I'd done all my homework. Look, I answered all the questions, Mr. Owens. I don't see why you give me these worksheets if you're not going to check my homework. A+. A++++.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Ethan Strum, half the state.
William J. for the state.
James Owens for Sarah Boone.
Tony Anderson for Sarah Boone. Mr. Beck.
Okay. Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment.
Where's the other third of the defense team? TikTok.
Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much.
And enter Mr. Beck.
That cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday.
Yeah, that's what I thought, Dissy Mom. I thought she was just drawing an orange there, but then it said power and control in the headline, and I think what that was is like a graph showing these different wedges, and I bet the outer part is describing, how a controlling personality takes control, and the inner wedges probably all described different aspects of, like how that manifests itself in the victim. So if Sarah's painting herself as a victim, she's probably trying to study that power and control dynamic so that she can say, I was always afraid. I'm happy because I survived.
And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yes.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir.
So before the break, they were talking about getting an audio recording of it. I think they found a way to like transcribe that audio recording into a rough draft that's not the official transcript, but it's going to be enough for Mr. J to make his arguments here.
Bless you.
Oh, here come the bless yous.
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
This is interesting, too, because if you remember Pro Se Sarah, when she got handed a document and then had to kind of process it on the spot, how she was like wasting time but using the court's time to try and understand it. At least here you can see James he's reading it, digesting it, and going to make a plan. It's the difference between having a proper lawyer and Sarah, who, if she got handed this document here, would just waste 15 minutes of the court's time to make a point of the fact that, I just got handed this. There's no way she would be able to make anything more of it in 15 minutes than she can from the first glance, but she would waste everyone's time for it. You see, Sarah's already bored by it now, right?
Okay. All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not.
That's how you tell a judge he might be wrong. Not, you're wrong, Judge, like the Owens team. But, hey, maybe I wasn't clear enough, Your Honor. And if I wasn't, that's 100% on me. So here, let me just restate my request one more time so you and your infinite wisdom can rule. Be deferential.
Motion, though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA, 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111, Florida 5th DCA, 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida First DCA, 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the Battered Spouse Syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Okay.
Thank you. Response.
So, in a nutshell, what he just said is they can't say anything bad about George until they establish an overt act. So we don't want to hear any disparaging of him in the opening arguments because they haven't established an overt act.
I just have one question as to what time. Are we talking about voir dire? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt.
There we go.
In Holland, 916-750, at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So, hearing no objection from the defense, the motion will be granted.
Judge, and just my understanding, I'm clear on the record. It's just procedurally correct. Procedurally, before we can put evidence of that, there has to be a claim of self-defense. That has to come from someone, and in this case, we all know that has to come from the state.
Okay, received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right, thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes. Just my overall understanding is that the motions and the orders that the court has submitted apply to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain ways.
Okay, so all he's really saying right now is we just have questions about the flow of evidence at the trial. Certain things have to be presented in a certain order.
It has nothing to do with voir dire nor opening.
It has nothing to do with voir dire or...
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that.
That's good that Judge Kranick does that for him as well as for Sarah, but hey, I've made my judgment. I'm not going to reword it. It says what it says. It's clear enough.
Matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So, state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
Okay.
One by one, I assume.
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4.
Okay, we're pausing here because I'm now reading the power and control image that I have up on screen, and I just saw a sequence of words that sounds almost exactly like testimony. What did George do to you? Well, pushing, shoving, hitting, slapping, choking, pulling hair, punching, kicking, grabbing, tripping, biting, beating, throwing down, rape, using. That's exactly it. So I think Chris from Guilty Words pointed out, like, that's weird that you would use rape and, pushing with the exact same inflection, like you're reciting a list. This is the fucking list. This is what she was studying, and she literally gives every one of these symptoms of physical and sexual violence that's on the outer part of this power and control wheel. Pushing, shoving, hitting, slapping, choking, pulling hair. And she recites it like, I hate to go over this but she says every one of them with the same inflection, and it's because they're not personal to her. If you had been, well, we won't go to the hardest word. If you'd been pushed, you'd have that memory of, he pushed me all the time. Like, sometimes he'd push me really hard. And there'd be that little bit of a pang of memory of that violence occurring to you. Slapping, choking, okay, now, there's the time he slapped me open hand. Like, that's the first time he ever hit me directly. Whatever it is, there's going to be a personal, but you don't just go through a list like this unless you've been studying a list like this. Anyone who hasn't had a chance, let me just blow that up for people. So what I'm reading is the outer part of this wheel. And wow. So we catch her studying this. It's going to be, this is the 17th or 18th? 18th now. I think 3 days later she testifies, and we hear almost exactly this sequence of phrases, because she's a straight A student. She wouldn't get any of that wrong. Okay, back to your regularly scheduled broadcast,
etc. So we can ping pong it back and forth from there.
All right. Regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Kelly says the poll would make for a very interesting video or stream. You know what? With the Friday Night Ramble coming back, that seems like fantastic Ramble content. We will use this poll as a jumping off point to next Friday's Ramble. Who's worse, Sarah or Mackenzie? And further to that, I'll put up a community post that mentions that that's what we'll be talking about next Friday. And you can put links to any videos and say, if you're talking about who's worse, make sure you include, 3 minutes and 4 seconds into this Mackenzie phone call that was on AG Tactical or whatever. Post all those links in the comments, and worst case, I'll just start clicking links to the comments if I don't fully prepare. But Kitten Pusher, thank you. It's a big discovery. Yeah. The freeze frame was great because that was just almost, that was a little serendipitous. I don't think I planned to stop it on that exact passing of the paper. But then thanks to Suze Watt, who looked it up, found out that it's searchable. Team effort. Well done, Dan D. The Fine and Dandies have uncovered another little piece, another little factoid.
Response from the defense.
That's a great point too, A to B. So the worksheet itself would make a great short. I take the audio from the trial where she's giving that list of things, and I just leave the image. I could even superimpose. So not just the audio, but put the video over top of, maybe put her right in the middle of the wheel. Ooh, this is a rich chat today. I should be, wow. Oh, big thanks out to you guys. You guys are giving me ideas. Work.
You're referring to 1A1? We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions, or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by...
I'm not talking about 2. You don't object to 2. Talk about 3?
Well, I do need to talk about 2 now because this morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing.
Ooh.
Defense?
Okay, so hold on. Let's, you guys see what happened there?
Referring to our paragraph 2,
Yeah. I was distracted by trying to do the
Correct.
McKinsey poll. We've moved into a Richardson hearing. Let me just refresh us on what a Richardson hearing is. A specific court proceeding in Florida criminal law used to determine whether a party committed a discovery violation, meaning they failed to share required evidence or witness information with the opposing side. So in this case, it is the state that's saying that they were overwhelmed with medical records that are meaningless. And now let me go to the next slide. There's a 3-pronged test, so the judge is legally mandated to investigate the violation by asking 3 specific questions. Was it a willful or inadvertent disclosure? So, was it so they're complaining, look, all the files are upside down and backwards. They're not PDFs. They're not searchable. They're really just pictures of these text files. So I had to format. I had to do this. Did they do that willfully? Did they do that to waste the state's time so they wouldn't be able to prepare for the trial? Was it substantial or was it trivial? So if it was just a minor mistake, it's not really going to be a big deal. Whatever, he still has to decide it. And does it cause procedural prejudice? The judge evaluates if this violation hurt the opposing side ability to properly prepare their case for trial. and this is what Mr. J is going to be arguing, is that you don't give me 480 pages of medical documents, COVID tests, checkups, blood tests. It's a total waste of time. This is not an optional hearing for judges. If a Florida trial court learns of a discovery violation and the judge failed to hold the Richardson hearing, it is a massive error, and one where the appellate court, and this is important, would automatically overturn the conviction. So you can see how serious the Richardson hearing is. I don't think the Owens team takes it that seriously, but you can tell that Judge Kranick's like, okay, we're doing a Richardson hearing. It's happening. It's right now. And the Owens team is, now they have to answer for themselves. At this point, they're on trial. It's no longer Sarah's trial. It's a little mini trial within a trial.
My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 12.
Sorry to interrupt, because that's legal stuff. We're not going to get it anyway. But Meowgarita appreciates the new graphics. I appreciate your appreciation. I'm going to try and do more infographics. As I'm pre-watching a lot of this stuff, I realized it could be useful for me to come up with something that can sit up on screen when I'm doing my explanations, and then people who are more visually oriented can take their time to go over whichever sentence really intrigues them about whatever I'm bringing up, and then the audio people can still enjoy my fine voice as well. Best of both worlds.
43, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that
The ready.
Yeah, I'm just going to go back just a slight bit, because you can almost see Owen's face register, like, hold on. Why does he keep saying it like that? Like, this is Richardson hearing. Should I take this more seriously?
State had no objection to those.
Hey, Danielle.
State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the Advent Hill.
So the very first defense that Owens is trying here is, well, the defense gave us some stuff. Yeah. And if that was the case, we would have a Richardson hearing for that at that time. But now we're talking about your discovery violation, Mr. Owens.
The 119 pages, my understanding is we thought we previously.
Oh, and I'm sorry, you guys probably can't hear everything he's saying either. I'm going to just rewind it and repeat, Mr. Owens.
State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that
Judge, the 81 pages that
81 pages are not at issue.
I understand that
I understand.
they were given Sarah Boone from the Advent Hill report.
But they were given to Sarah Boone by the Advent Health report.
The 119 pages, my understanding is we thought we had sent them previously.
The 119 pages, my understanding is we thought we'd sent them previously.
We realized yesterday or last night that we had not sent them.
Then we realized yesterday, last night, that we had not sent them.
So we provided those to the state.
So we provided those to the state.
And what do the 119 pages evidence?
They're medical records from the hospital relating to
You know, they're medical records from the hospital relating to, a certain period of time. And now that's been whittled down to, I think she said, her testimony. Obviously that's going to be whittled down depending on her testimony. And whether or not it will corroborate. Thank you, Deborah Rockhill. Congratulations on making 1,000+ subs, Dan D. True Crime. Haven't caught a live in a while. Yes, you might have to scroll back. I think it might have been the one we were doing a live when Betty Broderick's death was announced. And I did, I think, a recap live where we were talking about the whole Betty Broderick trial rewatch and everything. And right at the end of the live, we made it, and I did this silly little dance. I really should cut that out and make it its own thing, too. In any case, thank you, Deborah Rockhill. It feels good now at the 1,000+. And I'm not asking for subs anymore. I'm happy if we stick with 1,030 people that are enjoying this community. This is as big as it has to get. Oh, and let's go back to what was the very last thing he said there.
119 pages evidence.
There are medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it would cooperate. Her testimony that she suffered an injury at the hands of George Torres.
That she suffered an injury at the hands of George Torres. So we'll only be using what we provided if we're able to get it to corroborate what she testifies to.
Okay. I need more specifics than that.
James Owens is a deer caught in headlights. He doesn't realize. And Mr. J, he's just the opposite. He's sitting there like, yeah, finally.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up.
Well, it's going to have to be matched up with
the dates that she was injured.
With the dates she was injured.
Which would coincide with the...
But that all goes to
which would coincide with
the irrelevancy issue. We're conducting a Richardson hearing at this time.
This is the second time he says it. He's like, this should register. You're on trial right now, Mr. Owens.
So I need to address...
All right. He's slowly realizing.
The inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
Let me just
Moreover,
ask the girls.
I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
It's interesting that Shelby Andrews is whispering because she's the only one that's not a lawyer on the team. Hey, thank you, Becky. You know what? If I ever make a dating profile again, that's what I should describe myself. Informative, thoughtful, and relaxed.
My understanding is the first 81 pages were medical records of Sarah Boone that we'd gotten from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break, and let me find out from my secretary when we receive it.
Okay.
The question was, when did you receive? I don't know, Judge. I have to talk to my secretary. If I talk to my secretary, I find out when I received them. This, I think, will mark the beginning of Margaret being thrown under the bus.
I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
My staff is texting her
All right. I'll make a note to
so that we can find out the date.
circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
So 550 pages of medical documents. Imagine, lawyers going through it. Obviously, there's some that's going to be relevant, but there's so much that isn't. And is that an intentional waste of time?
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those
Yes.
the DA said?
That's what's going to be offered into evidence at this point in time.
Yes.
We'll work on that right now.
Appreciate it.
Staff, you're in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified.
I don't know how many of you are Monty Python fans out there. That little moment just makes me laugh. I just think of the holy hand grenade. I don't know that we have time to describe the holy hand grenade sketch, but
Other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming.
Short form, the holy hand grenade in Monty Python, very strict instructions. You throw it on the count of 3. 4 is too many. 5 is no good. The person who's throwing it miscounts, like 1, 2, 5. No, 3. Just more absurdist Monty Python humor. I think that's from the Holy Grail.
Also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to the various medical facilities.
We had Sarah Boone sign a medical request, and we have sent requests to various medical facilities.
For records, and we're just waiting on a response.
We're just waiting on a response.
The objection sustained.
So I think he just sustained the state's objection to the evidence coming in and saying, no, that's, you haven't done what you need to do to present evidence in a timely fashion. I think that's what's happening here. The Holy Hand
Moving
Grenade
to
of
6.
Antioch. Oh, okay, that was just on the one item.
Certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages jail records regarding Boone.
Can you hear he's a little pissed about this. Last night, after business hours, I received 382 pages of jail records regarding Miss Boone.
Once again, I had to spend my personal time reviewing these records.
Romans, go home.
Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years.
I'm not going to embarrass her, but middle-aged inmate, 4 years, probably going to be some of her alcohol withdrawal, some of her, well, maybe we'll hear about a variety of medical conditions that we probably are better off for not knowing about.
The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135.
And remember, so this is all post-arrest medical records. And that's why he's like, I don't know where you're going with this, but she committed the offense in February 2020. You just sent me the last 4 years of her medical records. Who gives a fuck?
There's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. And so the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight,
Semi-cooperative.
unrealistic expectations, wants holistic treatment, doesn't like being housed alone.
Mr. J's both saying that this stuff's not relevant, but he chose this particular passage to read out in court.
Panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225.
So that's the evidence that was provided to him. And he's like, I don't know how any of this makes any sense. She asked for the Big Bay.
Goes through alcohol abuse, yes. Type, spirits, not wine. Last
Type, spirits, not wine. Little shade, like, we know that she drank 3 magnums of wine just before she went into the prison. But she put that spirits as her alcohol used.
Used 223.20 several times a week. The doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes. Type, spirits, not wine. Last used, 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail.
She was a little anxious before, exactly. It didn't just come on.
So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020.
No, that's correct. Victoria and a few others are bringing up. So Brian said vodka. And yeah, when she got her settlement, and this is like Sarah talks about, well, when we couldn't afford the vodka anymore, we switched to the wine. I'm sure that what happened is she couldn't afford the vodka either. She was living beyond her means, but using the settlement as, a slush fund, and was drinking her way through it to the point where the slush fund was gone. She no longer had money for heat for sun, had to ask for, money for Brian for this and for that. And it got to the point where, you could always pick up a magnum of wine or, $10 a shot. Much easier than asking for $30 at once for a handle of vodka that might last a week. But, $10. Oh, well, not quite drunk enough. Brian! Ooh, George, you got $10 more.
They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages
Beth, the Blue Jays were
of
robbed.
Jorge Torres's records.
That stupid ball under the back fence in Game 6 of the World Series. Sorry, this is a Sarah Boone stream. I can't start going on about the Blue Jays. We'll save it for the ramble. If there's time after Mackenzie Boone discussion next Friday, we'll talk about how the Blue Jays were robbed.
There's just a lot of COVID screenings and blood test results, and it's...
Friendly fuck you to Beth
we
of a salesman. Welcome to the chat.
Thank you. Response.
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that.
Your Honor, it's similar to the state. A few days ago, sending me 500 pages. We addressed that at that time. Now we're addressing this, Mr. Owens.
Yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. No, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but...
And there's questions about her anxiety. It says in there that the anxiety was not pre-existing, but we are saying that perhaps it was from being in the jail.
Generally, you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically is relevant? What page? What date? What document? You're not answering my question, Counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these.
So if you guys can't hear that, Owens is claiming that the evidence he introduced is evidence he doesn't plan to introduce as evidence.
This exhibiting evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
I'm depending on the experts, Dr. Werner, Dr. Harper. they will depend on this evidence.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course experts can rely on inadmissible evidence if within the course of that area of expertise it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State
again, if you're just listening, maybe just come back to the video for a second. The reaction Mr. J has, very animated. Let's even give him a bit of a zoom on this.
How are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Date didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I'll be providing these at the trial. I've not yet had Dr. Harper review these. But as Mr. J pointed out, evidence that isn't admitted as evidence can still be relied upon by experts. So this is all moot, which again could point to the fact that this is a Richardson violation by the defense.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask her to review these.
Okay. State with...
That was the only purpose.
Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right.
Okay.
Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay, all right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence.
Thanks for joining the chat, Jan Webb.
Moving to Exhibit 17. No, I'm sorry. 16.
She's so pleased. 16
is a repeat of 11, so the court's going to adopt its. Similarly, with regard to that exhibit, Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to.
Congratulations, Bernice.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about the prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania and maybe Massachusetts. We're not referring to those. We're only referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it?
Mm-hmm.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion.
So this might be a list of like the photos that didn't have any dates, and Sarah's like, "Oh yeah, no, I recognize that. That's the time he grabbed my arm."
It's oral testimony. That may be a different critter once the overt act is established.
A different critter
under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony about her injuries.
Her face looks like like an unmolded piece of Play-Doh, like, that somebody's shaping it into the shape of a face, but there's always an unfinished part. It doesn't matter how her face is sitting. It looks like, it's almost modeled into a proper face, but never quite done.
Photographs, the officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that we have to cooperate it and ask the court to take some judicial notice that there was a case file that was set up to handle criminal prosecution.
Okay. Mr.
Kitten Pusher has a new theory. Maybe because Owens knows he's out of his depth, he's avoiding the microphone so the public can't hear him be an idiot.
Jay?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that
Thank you, Kelly.
by some government agency is relevant.
Good reminder, too. The Dandy community page, it's not just Sarah Boone. It's a little bit more whatever's going on. So, there's true crime stories from my local area here in the Pacific Northwest. There's sometimes just what the fuck stories that, I'm never going to cover on the channel, but by all means, check it out. When we were doing Betty Broderick, there's a whole ton of pet photos from people who were watching. So yeah, check out the Dan D Community tab if you're never checked it out before. It's a fun little scroll. I try to treat it like a Facebook page for my site because I don't use Facebook anymore. So it's a chance for me to kind of just reach out and chat and enjoy the comments and I don't know, enjoy the community without having to do 50 things at once while trying to remember the 50 things prioristically, because that gets to be a bit of a headache.
What's relevant is if there is an overt act that gets testified to prior.
Detective Wolbefit says, why does her face sag like that? Extreme resting bitch face. It's like her resting bitch face needs a rest. She's like so on with her bitch face, it just needs to like do this this sag to like, oh, been a bitch for like 15 hours straight.
Instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits, and that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of Battered Spouse Syndrome and Dr. Brennan will testify.
Judge, part of Battered Spouse Syndrome and, you know, what Dr. Werner will testify about? I assume Dr. Harper will testify. Dr. Werner will testify.
Is this feeling by the victim?
It's this feeling by the victim of being battered.
That she has nowhere to turn.
That she has nowhere to turn. Her family can't help her. She's got no group.
The state attorney dropped 3 of the charges.
State attorney dropped 3 of the charges. All separate times that George Torres was arrested and charged with violence against Sarah Boone.
At her request, she wanted them dropped.
At her request, she wanted them dropped.
Part of the syndrome.
That's part of the syndrome.
But in addition, in her mind, she felt like the state attorney had let her down.
In her opinion, in her mind, she felt like the state attorney had let her down.
They could not, they dropped 3 of the cases.
They dropped 3 of the cases.
So she felt helpless.
That
That there was some outside entity that would protect her.
That there was some outside entity that would protect her.
That ties into her state of mind.
That ties into her state of mind.
So whether or not she felt an imminent threat.
As to whether or not she felt like there was an imminent threat at the time of this event. So
that may become relevant depending on what Dr. Harper says, Dr. Werner says about that, what Dr. Brennan says about that.
So that may become relevant depending on what Dr. Harper has to say about that, Dr. Werner has to say about that, or Dr. Brannon has to say about that.
As to whether or not she felt helpless because the state attorney's office.
As to whether or not she felt helpless because the state attorney's office
Was not prosecuting George Torres.
Was not prosecuting George Torres
But that
when she was the victim.
all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay.
We may be wanting to introduce something in the court record saying that the state attorney blah blah blah.
What does that have to do with prior criminal history? Because that's the topic here.
Nothing.
Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the prior criminal history.
Okay. All right.
I'll withdraw the prior criminal history. Again, waste of time. Thank you, Mr. Owens.
So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office Investigative Workup Report. Response.
That's to be used to refresh the officer's memory if need be.
That's going to be used to refresh the officer's memory if need be.
Okay. With that understanding, Mr. J.
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21.
Mr. Cacciatore's yawning. Mr. Cacciatore wants to get out and do some yoga, get his body moving. Keep an eye on Mr. Cacciatore here. I'm going to screen him up a little bit more. We'll lose some of Sarah for this. Oh, okay, that works. Keep an eye on Mr. Cacciatore in about 10 seconds.
Introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21. All court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the...
Mr. J is a math man. The second time he's pointed out a math error.
Wrong. I color-coded this, and I miscolor-coded this one. Okay. Then, based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state.
Okay.
Anything further, argument? Okay. I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Just for the record, we've got about an hour left in this video, although some of that is clock time, so probably an hour left in commentary and video, with fast forwarding available during dead times. And then we'll watch a few minutes of the beginning of the what's listed as day one of the trial. They do still have motions to get out of the way, so that's how we'll start. Well, that's how we'll end the video, and that's how we'll start next Friday mornings.
Judge Brian Boone, we anticipate is going to testify for the state. When he testifies
Judge Brian Boone is going to testify for the state, and we anticipate.
for the defense, and he may be considered an adverse witness or hostile
And for the defense, we anticipate he may be an adverse witness.
witness, and so we may attempt to establish either bias
So we may attempt to establish either bias
on his part based on some of the documents or orders in the court record or oral made
based off of some of the documents and reports in the oral reports.
reflect for impeachment purposes the fact
And for impeachment purposes, the fact that
that he has not complied with some of the orders.
he has not complied with some of the orders. If I remember right, I think this is where Judge Kranick's background as a family law judge comes into handy, because James Owens says something probably that was represented by Sarah, and then Judge Kranick's like, well, no, if that happened, then they would have filed 312.
And that the reason being is because of his feelings for the defendant. He's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that divorce
What does the non-payment of alimony?
Yeah, Judge Cranick knows this is like, you're not making any sense, Mr. Owens. Welcome to the Fine and Dandies. Mandy 13 has moved up to the pro se. Welcome aboard. The Fine and Dandies are glad to have you.
Have to do with what's happening in a family case?
Well, Judge, that goes to his testimony, that goes to his credibility.
Judge, that goes to his testimony, his credibility.
Whether or not he can be impeached.
You know, whether or not he can be impeached.
That her in the position that she's in now.
Her in the position she's in now.
He's biased.
He's biased.
And to show that he's biased, that he has not paid alimony for.
And to show that he's biased, we're going to have to... You know, he's supposed to pay $1,000 a month for a number of years. And he's failed to comply with those orders.
That shows his personal bias or feelings.
That shows his personal bias or feelings with Sarah Boone.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated.
Mr. J agrees with Brian. I can certainly understand why somebody might think they don't need to pay alimony when their spouse is incarcerated. That's a reasonable thing.
I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
Bingo! Not going to get it past Judge Cranick. He knows how the family court system works.
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened.
I think you guys can hear James Owens now. I don't know why it's louder, so I'll just not repeat him now.
And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a...
Speaking of the microphone, Rob in the ADR Pro says Owens was trying to make a power play by not using the microphone. Not a good thing, since Cranick and Jay could still hear his nonsense.
Violation of an order to pay alimony. What is...
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, under cross-examination...
But it sounds like there's pending litigation, including a relocation or... And I don't know, because that's not my case, and I haven't looked at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it, and I'll let the court know and the state know.
Can you approach us for a moment?
Hey, good to see you. Please approach. And let's switch back to a full-sized Boone view. Move myself up into the top corner. Let's see. Spend some time over on this side. How long are they going to be out for? Can't resist looking at that camera, can you, Sarah? Well, maybe this break goes for a few minutes. Oh, I just lost my sock. There we go. What else? What can we talk about while we are... Someone turn the mic on. Idiots! That's my HMO impression. Idiots! Ugh! Victoria Carmen asked, Dan D., do you know what county he practiced family law? I think it was in the same district. I'm not 100% sure on that, Victoria, but I suspect it was the same district. Or if they do have the same districts. One interesting thing is that prior to 2023, Winter Park was covered by the 5th district in Florida, but post 2023 it moved to the 6th district with Orlando, and that's only mildly interesting. It's not really that interesting, but the interesting part is when Sarah's original objection was filed, it was filed to the 5th district, and it was Tanika that pointed out that it went filed to the wrong district because there was nothing filed by the deadline. And I think the reason for that is when Sarah's case started, the proper appeal district would have been the 5th. If Victoria is asking which district did Judge Kranick work in, possibly thinking that he may have come across her case beforehand, it's possible that he worked in the 6th district, but prior, like she would have been incarcerated by the time the 6th district was also responsible for the Winter Park area. I know entirely too much about the 5th and 6th district of the Florida legal system for somebody who lives about 4,000 miles away. Yeah, and I don't fast forward past the Sarah zooms. If they're just going to sit here and zoom on Sarah, making her little faces with her Play-Doh face, that's just, that's what we've signed up for. I will skip past the clock. I'll skip past the fan, but I will not skip past the ISO cam on Sarah, because this is her sitting with it. This is the best, we want her to feel regret. We've always wanted her to show some fucking remorse. These moments are the times where it's completely out of her control. She can't sit and bitch. She can't, whine to another inmate, or maybe she can get out a little bit of frustration on the pad and paper with her stupid little rubber jail pen. But this is her sitting with the consequences of her actions. Yeah, peek at that camera. I'm talking about you. You feel your ears burning in the past? Prioristically? Yeah, butterface is another. I've heard that expression for a few people. I don't know that she's a butterface, though, because it's like, aren't you supposed to have a hot body? Butterface? Yeah. I don't know that she's a butterface, butter body, butter everything. Like, we just thought of a funny joke. We thought we'd come and tell you. Isn't that funny? I totally, now that I've come up with my theory about Sarah being the ugly friend, I think that Shelby and Lauren know the more time they spend next to Sarah, the better they're going to be looking on camera. Like, you got both of them looking like Bo Derek 10 out of 10 next to Sarah here. And so are they discussing the Power Wheel worksheet? Because we now know that that was one of the pieces of paper that she had in front of her. So that wedge, yeah, that's the good wedge. You want to make sure that you say this whole list: kicking, punching, throwing, raping. Make sure you say them all. Spitting on, throwing at, insulting, telling me I'm not a good mother. Yeah, no, don't forget, it's power and control, power and control. I don't know how long it's going to be. I should pull this up a little bit. I'm showing a little too much cleavage. Meanwhile, Sarah, why do you wear yours so low? I like wearing them up here on my chest, but, that's a look to wear them underneath the desk. It's an option. I wouldn't do it, but I can understand why you want to do that. Yeah, no, I would never do that. I prefer support. Yeah, no, I just like to free boob. So No, I can see that. You can save a lot of money.
I thank you all both for your arguments and clarifications.
I got to go.
Based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, the court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you.
The defense does not intend to introduce any of the 911 calls. Well, bad news, Mr. Owens, because I'm pretty sure the state's going to introduce
Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
I know exactly what this news footage is, and when Sarah expressed her distaste for it's the perp walk as she's leaving the interrogation with Scott and Chelsea and being walked out to her car. I was watching a Suma stream where she highlighted this and how the fact that she's making Owens bring it up here shows how much she doesn't like that footage. And because of that, I immediately made a short using that footage. I'll try and get a picture to pull up.
20.
Here.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
News footage?
State, do you have such an item in your possession? News footage?
No,
No.
not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Good question.
Court takes no action based on counsel's representation. Moving to 32.
Why did they have a sidebar when there's no jury? Candace asks. I learned from listening to a couple of the sidebars on Guilty Words with Chris. One of them basically, so it's not really a sidebar as much as it's an approach to the bench, but Owens is using it as a way to like, Your Honor, can you tell her? I tried telling her. Can you tell her that she's not allowed to do this? I don't know what, I'm doing all I can, Your Honor. I'm doing the best I can. So there's a couple of times where Owens is almost asking Judge Kranick to tell the client something like, I've told her. So I think some of the approach to the benches is for them to have a legal discussion. It's still on the record, but without it having to be, I don't know. I think it has something to do with them talking without Sarah anyway.
iPhone photo.
I need.
Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence.
Natashak is a new subscriber here. You'll find we're all very friendly. If anyone gives you a fuck you as a hello, that's an inside joke. Don't take it the wrong way. Sometimes we just say fuck you. Good to see you. The longer you hang out, the more you'll understand. But glad to have you, Nadi.
32, another iPhone photo file name. It's very long, so I'm not going to read it.
This does not intend to introduce.
Okay. As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG _embedded _1 _772.
We would stipulate. All right, the objection is sustained based on stipulation. Moving to
Welcome, this is
59 and
Forever
60.
Wonder.
I understand your objection state. Any response?
There's the power wheel.
Any and all exhibits previously listed by the state?
Mm-hmm. Yes, sir.
What's this? He's got a cell phone? What's going on here? Waiting for a text from Margaret?
Mr. J is a smart lawyer.
Judge, Mr. J is a smart lawyer. I didn't just freeze it doing that, did I?
With a lot of experience, he's board certified.
Board certified. What does that mean? Criminal Lawyer Reacts will tell you what a board certified lawyer could do.
Filed this motion in limine to disallow the battered spouse syndrome.
He's fired this motion in limine. In limine. Uh-oh. What is going on with my... Yeah.
Twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it.
Oh, hairball yarn.
It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But
Hairball Yarn asks, have you gotten super chats yet, Dan D? No. I'm allowed to have super chats. I'm allowed to have super stickers, and I'm allowed to have something else that's super. There's 3 super things. But I think that the members are the most super thing about Dan D True Crime. So I've turned off all of those so that all the money gets funneled into memberships or gift memberships. So if you want to give $1, you can give a gift membership for $1. If you want to give $2, you can give 2 gift memberships. You want to give $50? Barry Adams gave $50 once. 50 gift memberships. All gift memberships. That way, people who were introduced to my channel a long time ago, when all I did was a few music videos and wasn't doing live streams, they might get an invite. Hey, you've been gifted a free membership. They come back, check out the channel, see we've got a fun community. Like, oh yeah, I remember this guy. This is all right. I like this. So if you ever want to give something, give a gift membership. If you don't want to give something, you don't have to. There's never going to be any paywalled content. There may be, I was thinking of something that I could do as like a member bonus, but it'll be off topic at best. Like if we do, there might be a members chat about how to create your own YouTube channel or something like that. So the main content will never be paywalled. There's a minimal chance I'll do something off topic that for people if they're interested. But anyway, if you're interested in supporting the channel, buy a gift membership, buy your own membership, or just watch the videos and, share them with people that you like them. Yeah, there's no content. There's nothing extra you're getting, so don't feel like you need to buy a membership. But if you do get one, you get gifted one. There's some fun badges that you can use in the emojis. and it makes your name green. It makes it a little easier to see in the chat. As I start recognizing people, I turn them blue if I haven't seen them green for a while. There's some people that have been here for a long time that I don't know. Maybe they've even turned off moderator themselves, or I've offered it and they've said that they just like hanging out. If you want to moderate and you haven't been invited to, by all means, just ask for it. If you've been turned blue and you're wondering what to do, nothing. There's no moderation. There's no words you can't really say in here. If someone's being an asshole, you can time them out. But it's Canada. We'll go hockey style. Throw them in the penalty box for a couple of minutes. Let them think about what they did. You can play shorthanded. We'll all welcome them back on the ice when they come back in a couple of minutes.
We had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right.
Hairball yarn, save your money. I appreciate it, but if you can't because you're on your phone, I would rather you not buy a membership than buy it on an iPhone where half of your membership money is going to the iPhone people. When you're buying memberships, buy them on your computer or through youtube.com, because if you go through the app, you have to pay an app fee. And anyway, by all means, if you want to support, but you don't have to, and just don't stress on it. If you're enjoying the content, just enjoy the content. Eventually I'll turn on super chats, but I think that's to the point when it just gets too busy in the chat to even see whose names there are. Then there's a benefit to being super chat. But for now, do like Becky. Becky just gave out 5 gift memberships. Tori Massey, Marobi, Jess Coast, Jesse Bees, and Sue Klohetzi. You've all received gift memberships. Thank you very much to Becky. Becky again. Anyway, we'll move on from that. I appreciate the memberships, and it does a lot to help build up the channel. As far as super chats and stuff go, at this point, my expenses are low. I bought a MacBook to do the channel, so that I could make videos and stream and stuff. So that's an expense, but it's also, I have a MacBook and it's useful. So if I get to the point where I'm incurring expenses, doing FOIA requests and starting to, really be a journalist, maybe I'll turn on stuff like that. But at this point, your presence is a present enough. So, don't stress it.
To be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know.
And just to get us back,
he wants the court to make rulings
what he's
so
complaining
that he
about.
can tweak his opening statement based on the court. The same with us.
I'm on a big lag. Owens is upset because they had to say, and it was Mr. Henderson who said, the overt act is the hand coming out of the suitcase. And he's like, that was some sort of big revelation, and now that they know that, it's going to be so much easier to prepare for it. It's ridiculous, right? But Owens is trying to get the same. He's like, I want to hear what their case is against my client. Don't worry. You'll get that. It's coming soon, very soon. LZB, 3 months of membership, got the Pro Say C badge, moved up from Drunky the Bear and the Bloody Keyboard. Dorgan, you are not a moderator. You're in green because you're a member. If you're already green, I don't blue the greens, I'll blue the grays, but if you move from green to gray and then I see you in the chat and I'm like, oh, how did they get gray? It was probably because they were a member at the time, and then, regardless, I like colors in the chat, and if you're gray, you're just as important to me too. Let me know if you want to be a mod, and I'll probably mod you up.
We don't know how to respond to their opening until they give it, because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So, in an abundance of caution, we've got to list everything. that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know the defense team.
The statement of particulars is him like, it just says that she killed him. You know, most statements of particulars, they say shot him with a gun. We don't even know. We don't know how he died. Yeah, you do. Yeah, you do.
Could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day, and that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games, it was Sunday fun day.
Sunday
Gets
fun
into
day.
the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do, and we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day, and right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence.
There we go.
I just want everybody to be clear and on the same page about that. Now, in regards to their request, renewed request for a statement of particulars.
You know, Indoor Camper says this is a great rewatch. Thanks, Dan. And yeah, I agree. There's something about watching it with the context of knowing, because a lot of this seemed pretty esoteric. You didn't quite understand what they were arguing about. They knew what they were arguing about. They had the evidence. But now that we've seen the evidence, we know what gets brought up in the trial, it's a lot easier to understand the machinations of these arguments, and it puts you in a much better place to understand future trials, being able to understand what's happening, you know, from a legalistic level. So I agree 100%. This is good. There's a lag.
They've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you.
So this is a preview. This is exactly how he ends up giving his opening statement. And some of this, I think, is because they decided, well, if we're not letting Owens use video testimony in the opening statements, what's good for the goose is good for the gander. And this is a preview of exactly how Mr. J delivers the opening argument.
Laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah. 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 Laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah. Unintelligible, drunken, slurred words. Laughter. Sarah. Sarah. Sarah, I can't breathe, baby.
Unintelligible, drunk laughter is, you might want to wriggle around some, make it extra for the video.
That's what I feel like when you cheat on me. Sarah. F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case.
That's our case.
That is an advanced.
They want to know what our case is. There's the particulars, Mr. Owens. That's our case. Well done, Mr. J. What is with my lag?
Depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago.
I wanted that in writing.
She was assessed, Sarah Boone,
the defendant was assessed at.
So remember, like we followed the case prior to the trial. You needed that in writing, Mr. Owens, to understand the case? You're a true crime fan. You were watching the trial like everyone else beforehand. You saw Miss Boone sitting there all alone. You thought, if the public defender's office won't stand up, that's when the corporate office has to stand up and get involved. So you flew in with your little Superman cape, down from the Panhandle all the way to the 6th District. And now you're shocked at what the case is?
The Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's excerpt. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Warner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder.
And again, he's acting like he's just learning the case now. Like, oh, okay, so that's what he's going to say she did.
Something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that.
Sorry, my pause is sometimes taking several button pushes. I might need to refresh the computer, but we won't do it before the end of today's stream.
Prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. And I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant.
Okay, quick poll for chat. A to B asks, is she trying to wiggle her nose like Samantha from Bewitched? And my question isn't whether she's doing that or not, which is an interesting question in and of itself. How many of you have looked at the dishes in the sink at some point in your life and just tried a little sneaky? Yeah, I've tried it and it doesn't work, but I can admit it. Why not try, right? Wouldn't it be amazing if you had that skill your entire life or had that magical ability and never gave it a shot?
Reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call-outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
I don't know.
Yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining.
Oh, yes, you are.
45 days, as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request.
We made
Whether or
attempts.
not we're going to call them, the law says.
The look on Sarah's face, too, like, yeah, attempts. You don't try, you do.
Listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days.
The look.
We have gotten
I'm not
witnesses
complaining.
or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal.
Sarah Boone.
Fundamentals. But the defense lawyer
Did he call her Sarah Bruin?
makes the decision about which witness.
He said Sarah Bruin, but Sarah Bruin, a Bruin is a bear. Shout out to the Boston Bruins people here in the chat. Sarah Bruin is a bear. Drunky the bear. Sarah Bruin. And Bruin. Well, she doesn't drink beer. No, we'll stay with the bear. Sarah Bruin.
So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
I got it. No. Well, I hit it. And you notice he said the court will take a short recess to address the Richardson violation. It's not whether or not it was a violation. It is a violation, and now he's going to address what the what the result of that is going to be. Recompense. Zoom right in there, cameraman. I love the cameraman for doing this. Like, I'm sure his camera hates it, but she glances just to see if it's still looking at her. Like, okay, I guess I just got to keep making myself busy. Did he blur the focus intentionally just so that he didn't have to stare at her? It's not like the focal range changed. No, he's trying to get in. He's looking for blemishes. He's reconsidered the wisdom of his camera movement. No, he's back. What an awful, awful looking... A little dandruff there, too. Yeah. Oh, I wish my pause was working properly. Definitely saw a flake on the left ear. Okay, the audio's been cut now. Stare into that camera there, Sarah. Let's see how much longer we have of this. Okay, we're going to save about 15 minutes. Oh, he's really good with his breaks. He says 15 minutes, and it is 15 minutes. We'll just wait until the camera leaves Sarah's visage before we move. Yes, Lizaloo. We found that fact out, actually. And welcome to the chat, Lizaloo, this sold roll. Earlier, as they were discussing the evidence, I'm going to go to main me. Let me just full zoom this. Mr. J was discussing the different file names. And one of the things Mr. Henderson complained, oh, we don't know. The evidence, it doesn't even have a date. And Mr. James is like, every file is named 2022, 12/25, 109. That would mean it was from 2022, 12/25, 109 p.m. So the dates are in the names. But on top of that, he said, now, that might not be the case for some of the videos if they were recovered from unallocated space, meaning they were deleted, but Cellbrite was able to say, okay, we found portions of a video file, we found this text file that was deleted, whatever it is. But then he goes on to say, but for example, the suitcase video, that's titled 2/23/2020, 11:53 p.m., blah, blah, blah. Basically, that is the proof that she did not delete those videos. Those videos were just they were just sitting there in her photo. They were there to be extracted with full metadata, full everything. There was information that they used from the deleted parts of her phone, and I think it may be stuff as stupid as the artwork pictures where she's just, taking pictures of artwork while complaining about being domestically violated. But it's a great point that Lizaloo brings up, and yeah, she didn't delete it. She forgot she took it. Let's go back to the trial footage now that we've given me a second. That was my time on camera. Oh, let me refresh this too while it's... Yeah, your little twitchy face. And there we go. 15 minutes of our live saved. Should be coming back to record any second now. We just save 5 more minutes. I think that's about it. Oh, got playback speed slowed. Okay, courtroom audio is a little clearer. Oh, we might be able to pick up whispering between James Owens and Sarah here.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Hello, Blink Bunny.
Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard...
Sarah Boone is sitting before me in a shoulder-padded blazer that is 2 sizes too large and a piss yellow shirt that she was wearing this morning.
To the Richardson hearing with regard to item 6 in the defendant's 5th amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide...
And that's what I was telling you, that the trial footage starts with motions hearing, so the trial footage doesn't actually start with the trial. It's just a little bit more of this. So we'll watch a few minutes of it just to get our feet wet. We have 10 minutes left in this video.
Provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured by agreement.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
I think it was number 2 was the 119 new JPEG pages purporting to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow.
California Dreamer, welcome to the chat, speculates, you can't convince me that that blazer isn't Owen's, and he let Sarah wear it. I'm going to take you one further. We'll say that Owens was expected to go and purchase clothes for Sarah, and instead went through his own closet. That'll fit her. This'll work.
And you were to provide an edited version of those records that you seek to offer into evidence, Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
So this is like, Your Honor, they did it too. Listen to how reasonable these last-minute witnesses are compared to the defense throwing new witnesses at a state 2 days before a trial that's been 4.5 years in the making.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for
FDLE, Florida Department Law Enforcement.
an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst.
So there's an analyst that was already set to be a witness, not available. Maybe it's a maternity leave, maybe it's a vacation, who knows, whatever it is, not available for the trial. So another analyst from the same department has been substituted.
So that's our reason for the late disclosure on Byrne. Who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. And what I would expect will not be lengthy nor expensive.
Because all they're going to testify to is, what's your name? Where do you work? How long have you been a 911 operator? This tape here, does this represent the audio recording of the call you took on such and such date? Yes, it does. Thank you. They're not testifying about their opinion or anything else, just chain of custody. That evidence is what it is.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay.
Mm-hmm.
Any other positions, Mr.
Hairball Yarn speculates that the clothes are Mr. Owen's wife, and he just repurposed her wardrobe. That would explain why everything's so ill-fitting.
Mr. Owens? Okay. All right. State will afford the same opportunity to the
Oh, good point from I'm Not Buying It. Did somebody swap mics on Mr. Owens and Mr. J's table? Because now Mr. J is the quieter one. At least he projects a little bit. You guys can still pick him up, I'm guessing.
defense as provided by the state to the defense. Court's going to be in recess. It's 11:27.
Oh. Hang on.
Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury select.
I think she even says, what about my motion too? Oh, hello, Kat. Hi. You want to be on camera? Okay.
Madam Clerk has advised that Jury Services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the Jury Services to call them and tell them they do not need to report. With regard to the Orr-Tennis motion as to Ms. Boone's request for snacks, the Orr-Tennis motion is denied Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial.
Denied.
Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
What do you think about that, Sarah? Come on, tell us with your eyes. Brah. Well, I can't just hold you forever. I'm on the stream. I know. You think the people want to watch that again? One more time, eh? Okay, we'll go back and watch that one more time.
So stipulated, juror number 25 wearing badge 60.
I love how Judge Kranick waited till the last possible minute. Like, this is such a stupid motion. I'm just going to toss it off after I've already said I'm done for the day. And then, oh yeah, this.
3 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the or tennis motion, as to Ms. Boone's request for snacks, the or tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
She doesn't look to Owens because Owens probably told her it's a stupid idea to ask for snacks. So she looks up at Mr. Henderson, who doesn't give her the reaction she's hoping for. Go back in here.
Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the
Look at Mr. Henderson. What do you think? Can you believe? Not even, 2 peppermints?
record.
Back to her paper, and then it'll be a little eye roll to herself. And then the little, I wonder if Lana's watching this. Yeah. Well, we always knew that was never going to fly there, Sarah. And now she just has to keep glancing up at the camera as the disappointment registers. I think that Shelby Andrews did a great job of distracting her when Judge was giving the ruling on that, so that she didn't immediately show disdain, but she was only able to hold it for so long. No soup for you. No soup. You want to do the upside down for the people? So can we appeal the snacks motion? We can appeal it? No? Because I'd like to appeal it if we can still appeal it. Can we renew the motion? Maybe upstairs? Maybe we can go up to his manager? Well, let me just enjoy this water. This water here is so much better than the jail water. Oh my God, I have to finish this. I'm so parched. Ms. Boone sits before us, unshackled. Officer Pink Cuffs, will you please remedy that? Thank you. I don't know if you guys can hear the cat. Oh, the cat knocked off my windsock again. Yeah, it's a good kitty. That's a whole different kitty. That is a whole different kitty. All right, Sarah being let out. So, push her into the door that's still closed. That's a good one. What a good cat. You're a good cat. Yes, you are. I got to put you down. I got to switch scenes. I'm sorry. Well, maybe I can do it with one hand. Maybe I can do it.
Late morning,
No.
perhaps early afternoon,
No.
somewhere in this time range.
Shh.
Several hours later.
That's how far I watched ahead.
And she goes
That's an
downstairs.
hour and 23 minutes. Let's just watch the beginning of the court. All right. Say goodbye to the people. All right. Down you go, cat. Ah, you're caught up. There we go. All right. Temptations. Yeah. No, I'll pay you for your appearance. There you go. All right. There's the file folders that hang up right where the jury sits. We've seen Sarah appear in that part of the courtroom before. Oh, I can see movement, reflection in the file folders. People are entering the courtroom. You know, the paw in the face. So I learned that, cats don't like being put upside down generally because it exposes their belly and, it's a safety thing and all of that. But it's a trust thing too. So I learned that if I let the cat put the paw on my face just enough that it, if it's not happy with what I'm doing, it can give me a quick swat. I haven't had to be swatted in a long time. I've kind of learned I've learned the touch that the cat likes. So, but that's sort of the trust boundary between the two of us. If he can put a hand on my face, then he feels very comfortable being upside down, knowing that if anything is not to his liking, he can give a very subtle indicator, and I'll know that it's time to stop. It's a big cat. I think it's a Norwegian forest cat is the breed. It was a rescue cat, so you can't be completely sure about the lineage. My mom thought it was a Manx, but I think Manx are much bigger. Still quite a big cat. I think it's about... okay, well, nobody cares about your... You're not heavy. You're just big boned. About 11 pounds. But you're good for your size. You're a big cat. Well, actually, I can correct a thing I said on a previous stream, too. I think somebody asked how big I was when my mom was on the stream, and I said 10 pounds. I was overstretching it. I was closer to 8 pounds. 8-pound baby. Still big. VC wants a pony. That is 10 Dandy True Crime gift memberships. Don't worry, we're not on pause here. We're not on pause. California Dreamer, hey, welcome to the membership crew. PSR 76 here in the chat, membership for you. Robin the ADR Pro here in the chat, membership for you. Corey White, haven't seen you for a while. Hopefully you show up and get a chance to enjoy that membership. Roberta Real was here today. Marsh, Lynette, Carrie Bintkiza. Oh, that's Bintazaya, maybe. Carrie R.H. Bintazaya. That's a great name. I bet if I pronounced it, it would sound even better. Kevin Brady, fellow Canadian, welcome to the membership crew, Kevin Brady. Miss Erin 84, you round out the memberships. Yeah, that's not a Manx. That's not a Manx. Maine Coon, maybe that's what she thought it was. And even then, not quite a Maine Coon. Like, they almost look like bobcats. Are you kidding? This looks like... I know if I move this forward, it's going to just have her here, and I want to have the entrance. 718. Okay, no, things are moving. Things are moving. Wheels are in motion. If you guys enjoy the music of Frugit, Frugit, the cartoon cat in the Frugit videos is very similar to Cadillac the cat there too. Thank you, Carolina Hurtado, who extended a big thank you to VC Wants a Pony. And yes, congratulations to everyone who got a membership. If you have a membership, you can refresh. I think you have to refresh the feed to enjoy the badges, but then the badges, hey, they're back. I wasn't able to get emojis or badges for a long time on mobile, almost 2 or 3 weeks. But it looks like that has been remedied. VC Wants a Pony got her own membership as well to go with all those gifted memberships. Congratulations, VC Wants a Pony. The Pro Say C badge is yours. 13 Mandy has a client watching soccer. Finds soccer to be the most boring sport there is. Now, I played soccer so I can appreciate some of the finer points of it. But I think any sport that you're not interested in is the most boring sport. This is an interesting point here, too. So, first day of the trial, who were all these people sitting up at the bench? We found out later. I think we watched 2 or 3 days of trial before we figured it out. But Judge Kranick has, I don't know, interns, law students, whatever, kind of shadowing him. I think he told them, I'm about to do one of the most fascinating cases, not on the matters of law, but on how to manage a crazy defendant. And if you guys want to test your ability to keep a straight face at a trial while sitting on the bench, this is the trial for you. Anyone who starts laughing, anyone who smiles, you're out of the program. Because they do a great job of just sitting back there and observing. But yeah, for the life of me, we couldn't figure out who they were the first little while of watching the trial. I even speculated, I thought they were there because there was that guy who jumped over the bench at the judge around the time that this happened. So I thought they were security, but they're not, super tough looking guys. So that kind of was out. Yay, the badges are working for the phone people. Now they just have to figure out how to pin comments to the top and we'll be set. Little thing, I've got 6% on my phone and I use the same cord for my phone as I do for, he's got the billboard pictures, as I do for the phone that I'm using as a camera. So I'll probably end this stream immediately after my phone dies. But I do have enough charge on both the laptop and the camera phone that you guys won't be affected. But my chatting abilities will be diminished by half. What other interesting stuff is there to pick out of this first day? Let's change the text template. Let's just get rid of that for now. We'll hide that.
Bless you.
Yeah. Let's start the bless yous. Another one to say is still having an emoji problem. I had them up until this morning. Hold on. Oh, no, never mind. They're not all fixed. My member ones are available, but the YouTube ones still aren't here. Member emojis have been fixed, but not the YouTube. The little the little monster guy. Ah. I like using the green smiley guy too. Not too many of the YouTube ones I use, but they're useful. There's the power wheel. You study that, Sarah. We know all about your power wheel now.
I'm ready when you are.
William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson, Sarah Boone.
Kevin Beck, Sarah.
I do.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right. Ms. Boone is seated at counsel's table wearing a black suit and
That's
a
him.
pink blouse. She is in custody in this matter. However, there are no restraints that are affixed to her person. So we will be standing when our jury enters and exits. Before we bring in our jury this morning, yesterday the court had reserved on a Richardson hearing regarding Exhibit 2.
So we'll just watch the results of the Richardson hearing and probably cut this off Well, fairly quickly. Interesting thing to take note of here. That's the murder weapon. So as we watched the Betty Broderick trial, there were a couple of mannequins that were in full view of the jury the entire trial with pointer sticks showing the path of the bullet wound, silently testifying just behind the court clerk. I wonder if that's why the suitcase had to be placed in a box rather than just sitting there in the cart as a suitcase. But
identified in the defendant's fifth amended reciprocal discovery exhibit list, specifically 119 pages of records from Advent Health Winter Park that were provided to the state yesterday morning.
Thank you, Hairball Yarn, and everybody who doesn't have emojis, try that. If you've got a blank screen, if you're on the phone and you hit the little smiley face, and then you get those emojis, swipe to the left, and now you get the YouTube ones. They're just in 2 rows, but you get all of them. So I imagine anybody I think we've solved the emoji crisis. Thank you, chat. Everybody who learned the solution thanks to Hairball Yarn, if you got your emojis back, share it in all the other chats. Let them know that the fine and dandies solved the problem.
By way of USB drive. Yesterday, the court had ordered that the defense was to provide an edited version of only the records pertaining to anxiety and the lack thereof, or anything pertaining to those matters, but before 9 a.m. this morning. Was that done, Mr. Owens?
Yes.
Okay. Mr. J, have you had the opportunity to review the culled down list of 119 documents?
Yes, sir.
Okay. What is remaining of those 119 specific JPEG images, and what do they pertain to?
Most of them deal with just billings, observations by the medical personnel, so don't necessarily apply to the issue of anxiety, as the court had indicated. I did include certain pages that discuss depression issues, as I believe that they were related to anxiety, and then I've identified 4 or 5 other pages that are not anxiety related that may be relevant to the case. I've described that.
Of those 119 images, how many are being sought? 15? Okay, thank you. State response.
Apparently, these are all just related to a January 23rd, 2018 admission at Advent Health Winter Park. So it appears they're not seeking to introduce any records from other instances that were contained in the records that were first disclosed to the state on September 27th.
Do you speak of the 81 pages?
Yes, sir.
Thank you.
Nor the new 119 pictures that still not in a PDF form. So of the 15 pages, the first 2 that they list are pages 9 and 10 out of 111. And I believe I've identified them as best I can. However, the Bates stamp from the hospital is over other text, and there is no other Bates stamp. So I'm guessing that it's pages 9 and 10 out of 111.
VC Wants a Pony, you are the lurker of the day for this Friday, June 18th. Giving out free gift memberships when you're not even sticking around in the chat for all the thank yous. That's altruism at its finest. Thank you so much.
It appears to just be a health information sharing sheet, like a contract. I don't understand the relevance of those 2 pages. Pages 21, and then they skip 22. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for.
But
and
for.
I apologize that there is a but for. The fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26.
Oh.
However, without...
Well, never mind. It's Friday, June 19th. I've lost a day. I'm like on daylight or full day lost time.
Page 26. We are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms. She is at 165 for ethanol.
So I was kind of chatting, but this is what I wanted us to stick around for this. So he's saying that the initial intake report for Sarah, she's complaining about, anxiety and whatever. Her alcohol was at 1.65, which means twice the legal limit, which means, was she drunk at her interrogation?
Depression symptoms. She is at 165 for ethanol, meaning when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. 23, 24, and 25 are all part of her initial assessment on 123.18. We don't object to those pages, but for, and I apologize that there is a but for, the fact that at the bottom of page 25 begins her toxicology screening, and that does go into page 26, and they did not indicate that they want to use page 26. However, without page 26, we are going to experience relevancy issues and a 403 objection from the state. And that is because in her toxicology screen, for which she is coming to the treatment to seek treatment for depression symptoms, she is at 165 for ethanol.
So this might not be on her intake. This may be drinking within the jail?
Meaning, when converted, it's 0.165 grams per deciliter, over twice the legal limit. It's a central nervous system depressant. We are going to have at least one medical doctor, well, two. The forensic pathologist will testify for the state, and then our expert on battered spouse syndrome, if we get to that point, is also a medical doctor. She's a psychiatrist, not a psychologist. Will tell us that ethanol is a central nervous system depressant. I believe even the psychologist will be able to get that information in. So we are objecting to pages 21 through 25 coming in without page 26.
If I understand your argument, is it a rule of completeness issue?
Yeah, I mean, in the sense that it applies to documents as opposed to
2018 health records. Okay. Thank you, chat, because I was off on that. So this is about the Advent health records when they were had just recently become a couple, and they're trying to tie in the depression to being part of George's relationship, and state is saying that would ignore the fact that she was twice the legal limit drunk when she came in to apply for that, and maybe that has as much to do with her her report as anything else. Thank you, chat, for clearing me up on that.
Statements. I mean, it is an out-of-court statement, so it is a rule of completeness issue, particularly when the symptoms and the complaints of the patient on that particular day were crying and being depressed and showing signs of using a central nervous system depressant.
So she went to this kind of place, basically, if she was documenting like she was on her phone, she probably thought she was documenting by going to a treatment place. You did this to me, your abuse.
The rest of the talk screen, pages 27 and 28, they did not list. We are not complaining that they are not including that. Page 29 is another page they listed. That's more of a narrative about her visit at January 23rd, 2018. We do not object. Page 43 is just her vital signs. We don't object. Page 44 is more of the initial assessment on this January 23rd, 2018 visit. We do not object, nor do we object to pages 45, 46, or 47.
What are pages 45, 46, and 47, just for my own?
More of this initial assessment of January 23rd, 2018 was my understanding.
There it is for sure, 2018. Thank you for all those corrections in chat.
Okay. Page 48, we are asking again that this be included. Again, I don't believe it's super mysterious why we are going from pages 43, 44, 45, 46, 47, and then skipping page 48, and then going to 49. But we do want page 48 included. On that page includes her height and weight at the time.
So, yeah, the Owens team said, yeah, we'd like pages 43, 44, 45, 46, 47, and 49 as part of this. And the height and weight, for whatever reason, they don't want to be part of the record. And it's like, no, I guess that's just as important as anything else.
Page 63.
What's 49? So seemingly that's included.
49 is just some results. Again, it's misleading and doesn't provide full context without what I've described as page 26, because part of the results on page 49 show that she was tested, shows that she was tested for the presence of ethyl alcohol or ethanol, but it doesn't give the results.
Are the results contained in another page?
Just on page 26, the one I previously described as wanting included.
So not following 49 to 50 or 51 sequentially?
No, because the pages they want from the 40s are 43 through 47, skipping 48, and we're asking for 48 to be included between 47 and 49 to make sure it's relevant and complete.
But they are also seeking 49, correct?
Yes.
Thank you.
They just skipped 48, just like they skipped 26.
Okay.
You just throw in just a tiny bit of shade. They just skipped it, just like they skipped 26. But we're not. We weren't just born yesterday. We're going to include those.
Page 63. It appears to be repetitive, but we don't have any particular objection to page 63 of the 111. Page 108 seems to be another part of the initial assessment from January 23rd, 2018, so we don't object to that. So basically we're asking for pages 26 and 48 to be included.
Okay, thank you. The the state did seek a Richardson hearing yesterday in this matter, and based on binding precedent by the 6th District Court of Appeal, Young v. State 369 Southern 3rd 1243, regardless of the culling down of the records, the court still is required to conduct a Richardson hearing. As to the issue of whether the defendant's violation was inadvertent or willful, Mr. Owens had advised that these documents were obtained sometime last week. He was unable to provide any specificity. He's going to confer with his office. Mr. Owens or Mr. Beck, are you in a position to advise when these documents were first requested, when they were received, and when they were sent to the state? Specifically, any documents pertaining to Exhibit 2, the Advent Health Winter Park records?
Judge, I did check with my secretary, Margaret, and my understanding is I didn't know that was going to be a question about when we actually sent it out. I know it was one of my trips down here. I got Sarah Boone to sign a medical release. We sent it to the hospital. It took a couple of weeks, I want to say. We got it last week. We don't know exactly when. We don't timestamp at our office when something is mailed in.
We don't timestamp at our office.
To my office. For whatever reason, the records did not get to Shelby, who was handling that issue, until late. And I think it was yesterday or the day before that she was aware that they had not been disclosed. We provided the copy to the state at that time.
So did these records come in batches? Because my understanding, based on the state's representation and their objections, was that the first 81 pages came on September 27th. Those were provided.
Those were separate. Those were records that some of the other lawyers, one of the other lawyers had received, and we sent them on, but the problem was they had notes on them. So we sent that 81, but it wasn't directly from the hospital, so we were trying to get a more complete, unedited copy of the records. That's why we made our request.
Okay, and when was the error identified?
Yeah, what's going on with her hair? For somebody who has a hair and makeup team. Yeah. Good call, Chad.
In time as to when these items were not sent, such that they were provided via USB yesterday.
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from one of our advance billing department, apparently it's a separate subcontractor.
Okay, I'll rewind so we can hear what Kevin Beck is saying. We're near the end here, too. Indoor Camper agrees that the faces behind Judge Kranick are really good at not reacting. And I think that's specifically what they've been tasked with is, you know, as a judge, you're going to need to sit in front of people and not give eye rolls and not, you know, look to each other, like smile. You can talk about it back here. We can all have a good time sitting around the honey bun dispenser and discussing this crazy case. But I'm going to have 4 of you out here a day, and every day you're going to sit and listen to the testimony and be pictures on this wall. You might as well look like a painted photograph because I don't want to see any reactions from you. 3047.
Unedited copy of the records. That's why we made our request.
Okay, and when was the error identified in time as to when these items were not sent, such that they were provided via USB yesterday?
Whatever date we gave them is when we realized there was an error, that same day.
Okay, my understanding that would have been yesterday morning.
Yes.
Okay. Anything else, sir?
If I may, real quickly, based on the invoice that was sent from
So this is Kevin Beck. If I may, real quickly, based off the invoice that was sent from the Advent Billing Department, through a subcontractor about the request upon request in September, I suspect they waited until they received confirmation of payment. It was $135, and we had to pay that. And we had that hurricane issue last week. Something to do, blah, 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 matter provided to the court. I did speak to. Did have something to blah, blah, blah on the record and matter of the relationship to. You might be just using words here. I was told they already had those records, so.
Any
So I don't think that was a problem for the state.
further argument or positions with regard to the Richardson analysis, Mr. J?
That's for the purposes of this hearing, I'd like this stack of documents.
Is that the 119 pages, sir?
No, sir, it's the 81 pages that we got on September 27th, 2024.
Any objection? All right, what was pre-marked A for the purposes of the Richardson hearing will be received without objection as states 1.
Robin, the ADR Pro, says, I'm beginning to think that Owens was playing the I'm a simple country lawyer who doesn't know how to do things in the big city, which is disingenuous nonsense. I believe he doesn't know how to do things in the big city, but I don't think he's a simple country lawyer. I think he's just a basic country lawyer. I think that he had a pretty good gig of negotiating pleas and, you know, oh yeah, you're in court. I know how to, you know, handle the public defender's office. I was once a public defender myself. Dom Russo mentioned fire ants, and immediately Sarah had to scratch her head.
Your Honor, there was just a reference that 81 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81 of these original 81 documents.
If you have a cell phone on,
Somebody's cell phone went off and it has a stupid ringtone. I'm going to go back and just rewind it a little bit to see if I can pick up. Whatever the ringtone is the voice of somebody saying something like, maybe it's something as stupid as Steve Sharilla's, answer the phone, answer the phone, answer the phone. But Judge Kranick is not happy. 32:35? No, that's now. Oh, it's harder to scrub because this is an 8-hour-long video. Okay, that's interesting to know.
Your Honor, there was just a reference that the 31 pages were all marked up by the defense. There's no markings. The issue and the confusion that the state attorney's office still has, though, is page 68 of 81.
It should be coming in right here if anyone's trying to listen to the cell phone.
Of these original 81 documents.
If you have a cell phone on, they need to be silenced and turned off, please.
Even Sarah's looking. Turn off your phone. Have some respect.
If you cannot follow the court's instructions, due to the publicity in this case, I will ask for you to be removed. Does everyone understand?
Good
Thank
point,
you.
Phil.
You may proceed.
That phone ringing just made Sarah remember the time that she used to own a phone.
And I realize that I've only had a limited amount of time to review the 119 pages that came in yesterday. And again, it's more difficult to review those because it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order.
Think how bad that is. So it's 119 pages of sequential documents, but they're not, whatever Margaret did back at the office. Oh, Mike was way down there. Whatever Margaret did back at the office, just like slapping random sheets on the photocopier and then recording that as a digital file. So some of them need to be rotated 3 times around, some of them 1 time back. Well, I guess 3 times one way is the same as one. Anyway, he was doing a lot more finagling with the files than he'd planned to, where you just, type in wounds or type in BAC or...
and I've done my absolute best to try and see if this page, which is 68...
Yes.
Great comment by
and
Victoria
referring to
Carmen.
68 of the 81 that was entered as 1, correct?
Yes, sir. It is sub-labeled within these records as page 2 of 14, and it appears to be a...
Victoria Carmen opines that her cell phone may be the best money that Brian ever spent.
Part of her visit on January 23rd, 2018, and in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant.
Liar. That's what I wanted us to hear today. So on one of her intake forms, alcohol use denies, tobacco use denies. No, I don't use, my body's a temple. I don't put anything in here that is poison.
And I just haven't been able to find that, and so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I have not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance at those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide information.
Okay. I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning.
But Federal Express, which is the block away, for whatever reason, the road was being constructed, so they closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand to state.
Okay, appreciate it. All right. Any other
Paper copy's not much better than the JPEGs, but
argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first.
And that's how we'll conclude today's show. We'll let him give his Richardson ruling, then we'll come back to this next Friday. It'll be day one of the trial. Day one is the state evidence. We see that that a couple of people who lived in the townhome are the initial witnesses for the state. They're going to testify to the sounds that they heard the night before. There's a huge block of time where they're off. Then Brian testifies. Maybe next week we'll go until Brian's testimony completes. And then we'll pick it up for the second half of that the following week, which is the CSI that explains where she found the cell phone. Okay, perfect. Hey, Margarita got Doris Day parking. What is Doris Day parking, Margarita? Welcome back. You made it right in time for the end. We'll get the Richardson hearing judgment. Then we'll cut back to a little goodbye for me, and then we'll be back next week with 2 shows. I'm taking one more Friday night off this particular week.
All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages 26 and 49 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So the state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident as provided in the 119 pages of item 2 of the defendant's Fifth Amended Reciprocal Discovery Exhibit List. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement.
Oh, yeah. Nope.
The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps 2.
That'll be the black eye picture.
So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough. but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through.
Basically, if you let them show those big stupid billboard pictures of Sarah during opening arguments, if those same pictures get excluded due to objection later, the damage has been done, the jury's seen them, and, you know, we can't determine whether they think they're legitimate or not, but they've been seen. I'm going to stop it here because this is where we'll come back to watch it. The interesting side effect of that argument from Mr. J is that he can't use the suitcase videos in his opening statement, and that's why he's forced to do the reading of it, and we will get to that when we return to the trial with the jury impaneled and in the courtroom next Friday. For now, we are going to cut back to me. There we go. That was the end of No Snacks for You, the No Soup for You episode. My medical snacks are almost gone. I've eaten most of my fresh fruit. It's completely defrosted over the 6.5 hours of today's stream. Oh yeah, I was going to look for other things that are happening to tell you about, but my phone is dead, so I won't be doing that. What else do I have to report on? So, check out my latest parody. I did a Sarah Boone, Boy Named Sue, but it is Life Ain't Easy for a Gal Named Boone. I'm looking at ways that I can add music programs to maybe professionalize it a bit, but there is a fun, rough draft that's already available for you to enjoy, so please enjoy that. Make sure you don't miss out on Sunday Fun Day with Danielle Chavon. She also uploaded a video about midnight last night, my time, so I still have to watch that. I was just going to bed when I saw that, and I knew if I stayed up to watch it, I wouldn't get enough sleep for this show that I'm doing right now. So I'll get to enjoy that while I'm getting ready for graduation night, cheering on my granddaughter through her graduation. Next Friday night, we will do Who's Worse, Mackenzie or Sarah? And I can see arguments being made for both, so I can see that being a good discussion. I'm going to upload a community post where if you want to weigh in on, you know, Sarah's the worst and this clip says why, in the comments, post your links. All links are postable on my page. You do need to be a subscriber to Dandy True Crime to post on my page, but as long as you're a subscriber, you should be able to post. And you can post links in the comments to other channels. But yeah, post your evidence. If you saw an AG Tactical video where it's a particularly heinous conversation between Mackenzie and Natalie, you know, say, hey, from 4 minutes to 15 minutes of this, pretty fucking bad. And I'll go through the comments. We'll play bits of them. We'll talk about it. We'll just make it a nice, relaxed hangout kind of conversation. And that will be that. Oh, I was going to talk to you about... This is a story from 2015. Command copy. And let me bring that over into my live screen. Where is the live screen? So this, you know, predates Sarah's case by, 5 years, but was a real story. Yeah, sorry, Guardian, how do I, no, I'm not supporting with any amount. Yeah, that works. Moroccan man dies while being smuggled into Spain in suitcase. Is that live? It's not live. There we go. That's the page. So here's the story. The Interior Ministry spokesman in Almira says a 27-year-old man suffocated during a ferry crossing from the Spanish port city enclave of Melilla. I'm going to say that the L's are pronounced with a Y sound. Melilla. A Moroccan man died from suffocation while being smuggled into Spain by his brother inside a suitcase that was in the trunk of a car on a ferry crossing. The 27-year-old man had been found Sunday when his brother sought medical help for him just before the ferry arrived in the southern Spanish port. So this is just the course of a ferry ride. This isn't an overnight. So this kind of gives us an indication of how deadly George's predicament was. Yorez added that the brother, a Moroccan with a French passport, was arrested. The ferry had come from Melilla, one of two Spanish port city enclaves in northwestern Africa that are bordered by Morocco and the Mediterranean Sea and represent the only land route between Africa and Europe. Interesting. Thousands of migrants from Morocco try to enter the European Union illegally via Spain each year, especially through the enclaves. Okay. On Sunday, Morocco's Interior Ministry said 4 migrants from sub-Saharan Africa drowned while trying to swim around a fence from the mainland to the second island. Okay, so not much more info about it, but it shows. So 27-year-old man willingly getting into a suitcase, obviously not to die, and died because of how dangerous such a predicament and position is. So if Sarah didn't know, she should have known. And did you ever do that before? No. Why do you say it like that? All right, we'll go back to me, and then I will cut away from this screen so I don't have to look at myself. I will look at the chat. My God, we had almost 100 people for almost the whole show today. I had 117 votes on the Mackenzie Shirilla versus Sarah Boone poll question within the chat, which is incredible. That's, I think, the most response I've ever gotten on a poll question that we've done. So I'm definitely looking forward to doing that as a Friday ramble. I'm not buying it. Says, when I first heard of Sarah's case, I stopped making the old joke, well, smuggle me in your suitcase. Yeah, when somebody goes on vacation, like, oh, smuggle me in the suitcase. We know that she put the son in the suitcase. Yeah, I remember that just being like a, ha, cheap way to get a flight, but dangerous, very dangerous. Okay, is there any last things we need to address? Anybody needs to get out a comment in the chat? Anybody who's given gift memberships that wants a free super chat, always remember you can just put SC, capital SC, put your chat, and then end it with a capital SC. I'll see it, assume that you bought somebody a gift membership and that you want a free super chat for that effort. If you're milking it, you start doing them all the time, I'll realize that you're not buying the gift memberships. You won't get away with it forever. But what else do we need to know? I don't think we need to know much else. I think the stream was good. I think we had a good time. I see A to B, Door, Robin the ADR Pro, Phil for Dom Russo, not buying it. All hanging out in the chat late. Ocean Sounds 1 still here. Sarah killed the joke along with everything else. Yeah. The good thing is at least Sarah's provided as many jokes as she's killed. There's things that were funny before that aren't funny, and there's things that weren't funny before that are hilarious now, thanks to Sarah. Can't think of any of them off the top of my head, but there's a lot of things that happen in life where my Sarah reference is the reason I'm laughing, and I just have to laugh to myself because I know anyone that's with me isn't going to get the joke, and it's not worth taking the time to explain it. Dorgan, I love this chat too, and I look forward to seeing you all next time. Indoor Camper, as a newbie, I'm glad that you came out of your tent and said hello to us in the campgrounds. We're a good, fun bunch of people. We got through the Betty Broderick trial. There's some contention, some disagreement, because Betty's a much different defendant than Sarah, where, there's a very, very easy to have sympathy for her, depending on the information that you're aware of and, your personal opinion of the case. And I think that was a great testing ground for what this community our ability to agree to disagree, and makes it more fun when we get in on someone like Sarah, where it's very easy to agree and we can all just have a good time without the contentiousness. But I think even when we're contentious, we're polite, we're respectful, we have good conversations, and I think we all leave a little bit smarter, despite the fact that Sarah leaves everyone around her a little dumber. So it's counterintuitive, but we're doing it. Should we call it? I think we should call it. I think if you've got a medical cigarette, light them up, and I think I will light up and say goodbye. So this one's for Sarah. Not allowed in the jail. I just got those. Yeah, well, not allowed in the prison. This is the end of the live stream. I'm going to leave the chat open for 2 to 3 minutes for goodbyes, but I'll count this down from 10 just so it's not too sudden. It'll probably cut off at around 2 or 3, but this is the end of the stream in 10, 9, 8, 7, 6, 5. I would love to see Brian in one of these chats. That's a great thing to put out there, Deb Rockhill. I think Brian could enjoy it here. There's some people that are a little critical of Brian, but I think for the most part we have empathy for what he had to have gone through. It'd be interesting to find out what initially attracted her to her. I bet she was fun. I bet as a teenager she was like one of those people that you're like, life of the party, you know. I want to be around her. Everyone's looking at her. 4. If we're not at 4 yet. And yeah, if you haven't liked it, as Meowgarita says, everyone like and subscribe. Make sure that you're getting all of the Dan D content. Check out Danielle's show on Sunday. I may have something for her. I can't guarantee it at this point. I was guesting on her show last week, and and yeah, I might have something for her this week, but I can't promise it. So we'll go down to 3. And a 2, and a 1. That's it. You guys are fine. I'm Dan D. This is the end of the live stream.